Please all stand for the entry of the members of the panel. Honorable Attorney Maria Milagros Fernan Cayosa, Attorney Jose V. Mejia, Attorney Justice Honorable Justice Aurora Santiago Lagman, Honorable Justice Regino C. Hermosissima Jr., Honorable Undersecretary Michael Frederick L. Musni, and Honorable Associate Justice Diosdado M. Peralta. Congressman Niel C. Tupas Jr. will be joining us later. Please remain standing for the invocation, national anthem, and the Supreme Court hymn. Let us all place ourselves in the presence of the Lord. Lord God, King of heaven and earth, we lift up to you once again our affairs for today. Direct the minds and bodies of the presiding officer, the members, and the staff of the Judicial and Bar Council, so that their work here will always find its origin in you, and through you reach completion. Fill all nominees with truth, peace, and courage. Remind them, O Lord, that to serve you and your people is both truly a privilege and an obligation. May this experience bring them closer to you and their families, and may their lives be now and always a testimony of your saving grace and mercy. We pray for the media. May they always be grateful to you because we live in a nation with free speech and free press. Renew in them their commitment to truth, accuracy, integrity as they participate in this process. Finally, Lord, we pray for our President. Bless him with the purest desire to know and do your will. Inspire him to carefully weigh everything and to seek your divine help in making the right decision. All this we pray. Amen.
Bayang magiliw, temas ng silanganan, alag ng puso, sa titik mo'y buhay. Lupang hinirang, buyan ka ng magiting, sa manlulupi, kita pasisili.
Session is open.
Good morning to everyone. The public interview on candidates for the position of Chief Justice of the Supreme Court is hereby resumed. The candidates to be interviewed this morning are the following: Associate Justice Roberto A. Abad of the Supreme Court, Attorney Rafael A. Morales, Partner, CSIP Salazar Hernandez and Gatmaytan, Professor Raul C. Pangalanan of the University of the Philippines and Chairman Bantay Katarungan. That's all. May we request Justice Roberto A. Abad to remain for the interview, while Attorney Morales and Professor Pangalanan to please proceed to the holding area while we conduct the interview on Associate Justice Roberto Abad.
Ready, Justice Robert? Attorney Cayusa will first ask the questions.
Thank you, Justice Peralta. Good morning, Justice Abad. During the recent IBP forum, you mentioned the judicial reforms, and you also made mention of one which is currently in implementation, the guidelines for litigation in Quezon City. Where did you draw the inspiration for these proposals, Justice?
You may.
What inspired me is that I'm so unhappy with case congestions and delay in our courts. I've appeared in our courts for, I think, the last 40 years, 11 years with the OSJ and then private practice for 22 years. And I'm really amazed that the crisis in our courts has not been addressed. I was really working also on this kind of reforms when this was presented to me by the Quezon City on their own initiatives, because they thought that I would be the one to advocate it in the court and bank. And I did. Although it was delayed a little because some of our members are somewhat cynical over some provisions, but I prevailed over them to have it approved. And I understand it's working well. Thank you.
Justice, would you care to tell us, to summarize briefly, what these guidelines are all about and what is the purpose and how you managed to get the court to boldly implement them, at least on a pilot basis in Quezon City?
The main things about the new guideline is that it dispenses with direct examination, and all direct examinations are taken or replaced by judicial affidavits. So that shortens proceedings a great deal. That's the main thing there. And the others are lesser postponements. You're given a quota when you cannot postpone anymore, extensions, and then pleadings have to be a certain number of pages. And I really admire the judges and the lawyers in Quezon City for having put together this. Now, when I advocated it with the Supreme Court, in our court, I beg the pardon of Justice Peralta, but we were somewhat a very conservative court. And we tend to examine a lot of things, and it was a little delayed, and it was really, we really had a problem. So what I did, I told the court, we will hold one day, and you all come together, those who have any objections or comment, and we'll sit down. Well, two of them came, and then we discussed these things and made adjustments. And then when I presented it finally, there were other justices who also wanted later more time. But I said, these reforms cannot take place. This is our attitude. I'm withdrawing it already. I withdraw this proposal already. It's an embarrassment for us. And they approve it. You know, the court approved it because I really put my foot down there already.
This was implemented sometime in April this year. And what has been the feedback so far?
Well, I think they're doing very well. Huh? Some lawyers complained at the beginning, but they've gotten used to it. They're adjusting to it. They complain now of the judges that they have too many cases submitted for decision in Quezon City.
Do you feel, Justice, this is something that can be implemented nationwide in all the courts?
Well, Justice Carpio and I were talking the other day. I have another plan, no? Because actually I'm for just from abandoning the adversarial system that we have today, because that's very slow. It's a small funnel. Well, all the cases have to pass through this American system and adopt a combined adversarial and inquisitorial system patterned from successful European models. We're the only country who's doing this system that has taken us a long time. So I'm doing that also. So what we agreed with Justice Carpio is that we will do it in 2 phases. Maybe next week or within this month or next month, we will already come out with a resolution implementing these affidavits, judicial affidavits for all cases. In criminal cases where the penalty is not less than prison correctional or less and lesser, then it will be by judicial affidavits. But of course, I have my own, what they call that, advocacy. My advocacy is that all cases should be heard in one sitting, one face-to-face hearing with the judgment rendered at the end of the day. In common, in ordinary cases. Of course, there are extraordinary cases. Because if we follow the current system that we have, they tell me this Maguindanao massacre will take us 20 years to finish. If we follow this new system that I'm advocating, I think we can finish it in 6 months.
What are refinements that at this point in the implementation of the reform that you are advocating for have to be made, the refinements in those guidelines, so that it may be applicable to the courts nationwide?
Oh, yes. It will apply already. It will be, well, as you know, procedural laws apply prospectively to the pending cases. If it is pending, then it will also apply. Whatever they have covered, then it will apply.
Moving on, Justice. You came from the private sector before you joined the court in 2009, and you also came from the academe. And there is a story, and confirm if this is true or not, that the day before you were appointed, you actually went to court to appear, and you had an unpleasant experience with a judge. So I don't know if it's truth or fiction, but if there is truth to this story, what did you learn from that experience, and how has that affected your perception and how you deal with lower court judges?
Well, it's really fiction. Although I really had run-in with the judge. I forgot the name of the judge already, but she's an honest judge, by the way. Except that she is, what they call, I think she is ill. They say that she is ill. And she had a short temper. And I was presenting a witness, and he was telling me that, what they call that, I did not prepare for my cases. And that's not true, no? She somewhat insulted me, and well, I forgot already what it was. But I told him that she has no right to insult me. That's what I told him. I told her, because I prepared for my cases. So after that, well, I told her I am going to file for inhibition because of that. But later on, a friend of mine, just Elvira Panganiban or something in Quezon City, called me up. He said, best friend, told me about it. And so he said, I don't plan to file any case against her because she's an honest judge. That's not something I'm going to do to an honest judge. But I said that it's just a misunderstanding between us, and that's not my purpose. I can understand she has problems. And that's it. Huh? That's, although by coincidence, I became Associate Justice, and then she got sick, I understand. So, but before she got sick, we somewhat reconciled through Justice Panganiban.
Thank you, Justice. Now, coming from the outside, as they say, prior to your appointment to the High Court, how important is it to you today that an insider is appointed to the position of Chief Justice?
Well, if a candidate has what it takes to be a Chief Justice, he can be an outsider or an insider. But I have, of course, a natural bias for the insiders, because the insiders are tested. Their performance are on the record. You can look at it, and then you can listen to people and see what they have done. But if the president appoints an untested outsider who will serve for 18 to 12 to 20 years, you take a lot of risk. If later on he turns out to be mediocre, show-off, lazy, ineffective, well, he has to commit an impeachable offense to get him out. And you would have then bound the country to a Chief Justice for 20 years. So maybe it's not... so that's why I have a bias for insiders in that way. Not necessarily myself.
In contrast, what can a Chief Justice achieve in 2 years?
Well, I think a lot. For example, the reforms that I'm working on can take place in 2 years, and these are substantial reforms, like changing the system for hearing cases and decongesting the jails. I mean, also in a committee where we're working to decongest the jails and reduce the population into 1/2 in the next 2 years. And the rest, Your Honor, I'll sow the seed that may be reaped by the future.
Thank you, Justice. You chose not to inhibit yourself from acting on the petition filed by Solicitor General Frank Chavez on the composition of the JBC. The reason being, and I quote, "You found no compelling reason to do so." End of quote. In what cases did you feel compelled to inhibit yourself from participating, and why?
Well, when I feel I have a bias that I could not control or something like that, then I'm going to inhibit myself. And those compulsory inhibition that we have, or I've been approached, sometimes I'm going to inhibit myself.
I have one final question, Justice, but before that, may I just express the thanks of the IBP for always trying to innovate and for consulting with the members of the bar before you decide to implement something, and I hope that will continue in the Abad Court. My final question, Justice, is do you have any specific experience with respect to having to make a decision which may have been unpopular to the appointing power and that may have shown your integrity and independence from that appointing power? Could be as an associate justice.
Well, I was appointed by President Gloria Macapagal Arroyo. And when the Truth Commission case came up, I voted for the Truth Commission because my reasoning is that you can go no wrong looking for the truth. So I can take a position adverse to the one who appoints me.
Thank you, Justice Abad. Thank you, Mr. Chairman. I have no further questions.
Attorney Mejia.
Thank you, Justice Peralta. Good morning po, Justice
Good morning.
Abad. How will you assess your performance as an associate justice thus far?
I don't know. I've never really sat down to assess my performance, but from the record, I think I have one of the lowest, what they call that, pending records. The judicial cases, which is the one that we really matter, because some of the administrative cases, they're in our docket, but they are really being heard by the JBC and other agencies, so we could not act on them. But on the judicial cases, I think I have only 314 or something. I'm not sure, but it's in your record, Your Honor. And that's not. I think that's one of the lightest in the court.
Si Senator Sagisag po nominated you, no? And in his nomination, he pointed out that the reason for him nominating you is that we need a transitional Chief Justice like you that would provide, if I may use his term, a calming effect. How will you provide po that calming effect in the Supreme Court as Chief Justice?
We have a wounded court today. After the impeachment trial, well, we have a problem that we thought, well, we somewhat taken aback by this development and discouraged most of us. The way I look at it is that if I become Chief Justice, the first thing to do is to forgive. Because you cannot have, what do you call that? You cannot have what do you call the healing unless there's forgiveness. I hope the President will forgive us also and will forgive the legislature and we can reconcile. That's the first thing I believe that how I'm going to start it if I become Chief Justice. Can I just get a thing?
So Justice, but if seniority po is a concern for the so-called outsiders, it should also be a concern for someone like you who is less senior in rank. How would you address that concern po?
Well, I think, I was nominated, not actually seek to be appointed Chief Justice, but I had to honor those who nominated me, and then I believe that with God's blessings, I can do it. And actually, what we're offering is service, to be a servant of all, and it's not really as if being a Chief Justice, makes you a better person. No, it's really a job that you have to do. So I think my colleagues are going to understand that. And I can say that, from Justice Peralta, maybe I can tell you, that I work very well with our court. As a matter of fact, in the last 100 years, there has been no internal rules of the court. And asked the Chief Justice to prepare one. He made me a member of that committee, and we had done internal rules. I am proud to say that I think I prepared the working draft of these internal rules. And then, when the chairman Natura vacated the post, they chose me to head the internal rules when there were 4 senior justices in the same committee. When we put up so that shows some kind of trust. So when we established the ethics committee that will investigate all complaints against the justices of the Supreme Court, and we had a secret voting, and we elected 4. I was elected into the ethics committee to investigate my own peers. So that is trust. And I think that is what we need, that's what a Chief Justice needs, not a sense of, what do you call that, academic superiority, but trust is important.
Kahapon po na itanong kay Attorney Ligarda tungkol dun sa divorce, no? At if I remember correctly, she made reference to the somewhat influence of the Catholic Church in the position of the legislative body in passing a law for divorce. No, may I ask you po, what principles should guide the separation of church and state?
Well, the classic answer there is that they should not get too entangled too closely to each other. Well, the Philippines, unlike the United States, the Philippines is somewhat more spiritual or religious, in a sense of we have prayers said in school and we have even catechism in the schools. So there's some tolerance for religious practice in the Philippines. As a matter of fact, we have Mass in the Supreme Court on Fridays. And I think it's a healthy tolerance because in one decision it says that religion is important also for keeping the morale of the population of the country. But I'm, of course, against religious personalities, what they call that, trying to influence political decisions. I'm against that.
you were talking earlier about adversarial inquisitorial system. Mayroon pong nagtatanong no sa text at saka sa ewan ko kung sa Twitter. Siguro linawin lang po natin siguro sa publiko yung marami kasing nabibighani sa panonood ng Law and Order, pagbabasa ng John Grisham, marami pong nabibighani sa konsepto ng jury system.
Sige.
Ano po ang palagay ninyo doon?
Yung jury system, mahirap lang tayong bansa, no? So, yung jury system, magastos yun. I-hotel mo yung jury. Wala nga tayong pansweldong mabuti para sa judges natin. And then, ang jury system, 90% of jury trials take place only in the United States. The rest of the world no longer practices jury trial, no? Except a few in Great Britain. See? Ngayon, what I am proposing is that to abandon the adversarial system. Pwede bang paliwanag ko lang itong adversarial system? Yung adversarial system, binigay sa atin ng mga Amerikano, mga 100 taon na nakakaraan. Dito sa adversarial system na ito, ang pinaglalaban ang nagdedemanda at ang idinedemanda. Ang ebidensya na padidinig sa judge, yung gusto ng abogado. No? Hindi yung gustong malaman ng judge para ma-decide niya yung kaso. No? Kaya nga, dahil doon, ang abogado pwede niyang habaan, i-delay ang kaso kasi siya ang nagdidikta kung ano ang ebidensyang pakikinggan ng judge. Yan ang ating adversarial. Second, hiniram natin ang batas ng Amerika, ang rules ng Amerika sa trial procedure. And do you know that those rules were designed for both jury trial and bench trial? Kung kaya nga dito sa atin, maski wala tayong jury, pag nagbibista tayo, parang may jury. Bakit? Yung judge natin, pag merong objection, ini-screen pa niya yung tanong. Sa Amerika, ini-screen yung tanong para yung barbero, farmers, wag nilang madinig yung inadmissible evidence, yung evidence na palso, wag nilang madinig. Pero dito sa atin, wala tayong jury. Ang nagdi-decide ng kaso, yung judge din. So, ang ridiculous na nangyayari, yung judge, ini-screen niya yung tanong para madinig niya yun lang admissible evidence. That's really ridiculous, ano? Secondly, sa jury trial, yung member ng jury, dapat wala siyang alam sa kaso. Diba? Hindi niya nabasa ng document, wala siyang opinion. Ideally. Kaya nga, pag-presenta ng ebidensya ng plaintiff at ng defendant, uumpisahan niya from the beginning to the end. Kaya at sa inyo, ng mga judges dati at saka mga practitioners, ano nangyayari? Tatanungin nung interpreter yung plaintiff's witness. Halimbawa, nagbenta siya ng motorsiklo, let us say, for 250,000. Hindi nagbayad, 30 days credit. Idinimanda niya. Hindi sila nagkasundo sa stipulation of facts sa kaso. Ang gagawin, iprepresenta niya yung plaintiff. Anong tatanong ng abogado? Do you know the defendant in this case? 99% ng mga witness natin hindi magtitestigo ng English. Gusto nila Filipino. So, merong interpreter. So, do you know the defendant in this case? Nakikilala mo ba nasa saktol sa kasong ito? Opo. Yes, sir. Why do you know him? Bakit mo siya nakikilala? Nagbenta ko kasi ako sa kanya ng motorsiklo, sir. Because, sir, I sold motorcycle to him. And then, when did this take place? Where did this take place? Who were present? If I show you a copy of the sales invoice that you mentioned, will you be able to recognize it? Showing to you the sales invoice. What relation does it have to the sales invoice that you mentioned? Anong relasyon ito? Parang kamag-anak, hindi yung magkamag-anak yan. So anyway, sabi niya, yes. And then, I would like to ask that the sales invoice be marked as our Exhibit A. So matagal, Exhibit A. I would like to ask the name of the buyer be bracketed, marked Exhibit A-1. The name of the article bracketed, marked Exhibit A-2. The name of the price of the article be bracketed, marked Exhibit A-3. The name of the buyer be signature of the buyer be bracketed, marked Exhibit A-4. You know, so it takes a long time. When the dependence time comes, ganun din naman. State your name and other... Because our rules is designed for a jury trial where the jury knows nothing about the case. But that's not true in our situation. We have a judge who has seen the pleadings, who has seen the affidavits attached in the criminal case, who knows what the case is about. Judges tell me, when I go there, because I've been going around the country, tell me that when they see especially in ordinary cases, when they see the complaint and when they see the answer and the annexes, they already know who will win the case. Yet it takes 3 to 5 years to decide that case because the judge has no control over the proceedings. It is the lawyers who dictate what evidence is going to hear. Dapat pwede nilang sabihin ng judge, teka muna, ang problema dito kung nagbayad o hindi. Ano bang ebidensya mo na nagbayad siya sa'yo? Your Honor, ito, meron siyang invoice dito. Oy, meron siyang invoice. Hindi ka pa raw bayad. Your Honor, bayad na ho yan. Ito ang check yung pinagbayad ko. Tingnan ko nga. Ay, meron siyang check eh. Bayad ka na raw. Your Honor, yan hong checking yan para sa ibang transaction. Para dito yan. Oh, oy, ibang transaction daw to. Hindi ho, yun yung transaction na yan. Meron pa ba kayong ebidensya? Wala na ho. Eh di, in a few minutes, the judge can decide the case. But you know, here, it will take 3 to 5 years to finish this case. Mag-a-appeal pa. So, in place of that, we are proposing a combined adversarial and inquisitorial system. What is the inquisitorial system? The inquisitorial system is actually the God's gift given to us on settling cases. When you go home, your children quarrel, 2 of them. What do? Well, do you say, oh, I will ask you to explain it first. Explain your side, argue it, you tell me your story. And then, so he begins. After 5 minutes, you say, reset, call again 3 months. No? Postpone 3 months. Oh, that's not the case. A true dispenser of justice is going to ask the questions that he needs to decide the case. Ask them. That's what we do. And you know, some children are articulate and some are not. It's the same case in our courts. Some lawyers are better than other lawyers. Some questions that are important for making a decision are not asked. And the judge in this process will be able to ask. So what do we propose? We propose a one-time hearing where all the parties will be present. This is something that is being done already. You know? I'm not reinventing the wheel. I don't claim credit for this kind of system. The lawyers, the parties, the witnesses come together in some kind of a round table, and then the judge presides over it. He swears all the witnesses at the same time. All right? And the judge starts to ask questions, with questions shifting from one witness to the other. That is an authentic confrontation. See? And then the lawyers, this is the adversarial side, the lawyers are free to conduct cross-examinations of the witnesses. In ordinary cases, this will be done in a GP. And then the judge, on the same occasion, will make his decision. And do you know the advantage of that? The judge making his decision at the same time. He has the clearest picture of the case. Second, the public that listens to the witnesses as they testify will be observing the judge. And if it appears that one party is really lying, the judge will be deterred from saying, this party wins. That's precisely the value of public trial. But in our present system, they hardly meet. You present the plaintiff today, 1/4 of his testimony. After 4 months, 1/4. 4 months, 1/4. Later on, up to about cross-examination, etc. The plaintiff and the defendant will never meet. But here, you will see the nuances of speech. The Bible says that conversation reveals the man. And that's the thing that... thank you very much for that question.
Maraming salamat po. Yun na po yung huling katanungan ko. Salamat po, Justice Peralta.
Justice Lagman.
Thank you very much, Mr. Chair. Justice Abad, good morning.
Good morning, ma'am.
You are known to be an innovator in the Supreme Court. In the 3 years that you have been sitting as an associate justice, what have you done to declog the docket of the court,
The Supreme Court
the
itself.
Supreme Court itself?
Well, we prepared the internal rules that somewhat define some of the problems that we have there. But let me tell you that the Supreme Court's docket is not necessarily clogged.
Yeah.
The Supreme Court is the best performer in appellate courts.
Okay.
About, I think I would admire the previous justice because they changed the system so that we're able to dispose of our cases better than before. As a matter of fact, we are now eroding very quickly the past. You say that we have problems because we really have old cases that have not been decided.
Yes, that's it.
But you should look at how we dispose of new cases and how we decide them. I think we are doing it very efficiently, although it stands to be, what they call that, further enhanced.
I think the problem is with the old cases, which have been pending with the court for a long period.
Well, we have an agreement. I think the justices are complying with it, but we are now eroding on those old cases. I think that's really a shame that we have those cases. We know, no, we ourselves are embarrassed by those things, so we'll work on it.
I see.
Thank you very much.
It's nice to hear that you're working on it. Okay. Now, you talked about impeachment also a while ago. In your opinion, did the impeachment of the former Chief Justice infringe on judicial independence?
Well, not really, not infringe.
Yeah.
No, I don't think so because
What
that's
is your
really
opinion on that?
that's really their function. Well, although the case is over, so now we can comment on it because I don't think there's any pending thing with us. What I did not agree with there is that the way the complaints were filed, the preparation of the complaint, I think was really hurriedly done and it was not somewhat indecent way. So I disagreed with that, and I think I joined the court in that kind of step. But I think that's past already.
Yes.
And I think as I said, we should
You have to move
forward.
Yeah, but we also want to know your thoughts
Well,
about
that's
it.
my
Because you
thoughts.
mentioned about
I'll stand
impeachment.
by that idea, by that position.
Okay. You were with the academe before, and you were the chairman of the bar examinations
Yes, Your Honor.
last year. Now, annually, only at least 30% of the examinees pass the bar examinations. What do you think, Justice? Is this an indication of the low quality of legal education in our country?
Well, yes, I think so. I agree that. Now we're trying to do something about that also. Although that's now within within the jurisdiction of the Legal Education Board.
Yes.
But we're working with the Legal Education Board to try to improve legal education in the country. Actually, what I've been suggesting, to go hard on schools to improve themselves.
Yes.
But I know that the key component of a judicial system is the lawyer. And so we have to raise the standards for admissions of lawyers. And what is more, I was suggesting, and we're studying it in our committee, to limit the bar examinations to 4 subjects only. For example, civil
What
law,
are the subjects?
remedial law, political law, and criminal law. The really basic subjects that beginning practitioners need to be able to go into private practice.
Okay.
In order to free more units for developing specific careers for lawyers. For instance, they can, like Ateneo is beginning to do it now because of my suggestion with SEDPRE.
Yes.
We're trying to work out where the academe will develop those who want to become judges
Yes.
and develop their sensibilities for being judges, their values, as well as their ability to dispose of cases. And some who will be litigators, and some who will go into commercial practice. So that first year and second year may be devoted to studying the basics. So, Anyway, when you become a lawyer and you work with a law office and you start to practice, at the time you look into specialized laws like intellectual property. You don't need to pass the bar, no intellectual property, to pass the bar. That's not the point, really. Well, in all countries, they don't have an exam like us where we cover all the laws. They only cover the really major subjects. That's why I said, our curriculum is so crowded that the students just learn the law, but not the practice of the law. I think that's what reform that we are looking at, Your Honor.
Okay. Now, so aside from activating the Legal Education Board, which I think they're just starting to take off, no? If you will be fortunate to be nominated and appointed as the next Chief Justice, how do you intend to regulate these law schools, aside from what you have stated?
Well, I have no, even if I become Chief Justice, I will have no power to close down these schools. But, well, I will I certainly would invite all the deans and maybe talk in schools, go there again, I visited them, and then ask them to, well, see their problem. No? What is their problem? Why is it that their students are not performing very well? We have to investigate the causes. It does not work sometimes that you just say you close them down. No? Sometimes you have to see, why is it not working for them? Why is it working for other schools? I will encourage such kind of conversation.
Okay. In relation to this, there is a question from our Twitter, Justice, and I will read it. How do you respond to criticisms that your bar reforms, namely MCQs, will produce lawyers who are good at guessing but can't argue?
My new MCQ.
MCQs. MCQ.
Well, my answer to that is this. Multiple choice questions is a tested measuring stick.
Yeah.
It is not as if we are inventing it. The whole world, there's no professional regulation authority in the world that does not use multiple choice.
Okay.
Because it's really, what they call that, it's really time-tested. Do you know that multiple choice, in a sense, asking these questions in a sense, is you cannot really, let us see, when you teach law, I don't know if some of you have taught law, you teach a subject, let us say evidence, when the finals come, how many questions do you ask? 10 questions, problem questions.
Okay.
So if they can answer 80% of those problem questions, even if you taught them 1,000 principles and evidence, your assumption is that they know 80% of that 1,000.
Okay.
So in a sense, it is statistics, no? Sampling, taking the sample from the mind of the students. So multiple choice is good because you ask 100 questions and the answers are exact. It is good for sampling.
Okay.
If you ask 100 questions in a subject, you can be certain, scientifically, they say, with 3% error, that you are able to test the percentage of knowledge that the person has on the subject. That's why we adopted it.
Okay. So,
By the way, I'm sorry.
Okay.
But we also have essay. We have an essay portion of the exam. But our portion of the essay of the exams require the candidate to prepare a trial memorandum that lawyers do. Trial memorandum. So that we want to test his ability to sort out the relevant facts, identify the issue, and prepare convincing arguments. See? Because multiple choice will not show true intelligence. Multiple choice will not show creativity. But the essay portion of our exams, graded by 4 examiners, by the way, not by just one. We have 4 examiners grading the trial memorandum and then assessing the ability of a person to prepare the trial memorandum. And do you know the result of this? The law schools have begun to shift the direction of their education from teaching the law to the practice of law.
Okay.
This is what we have done.
That's the good thing that you get out of it. Okay. Now, Justice, this is another question from a concerned citizen, no? Having been in the judiciary since 2009, have you ever reversed yourself when deciding cases and casting your vote?
Oh, yes.
Please cite a specific example.
Well, I think the one, I hardly changed my vote, but I changed my vote in that case of, Manotok. I'm sorry, I have to consult my more, what do you call that, photographic-minded justice. I think in the Manotok case that involves,
Yes.
well, it's still pending, so I don't want to comment on the merits of the case. Is it dismissed already? Well, anyway, in that case, well, I changed my vote because I felt that the first time I voted, it was a knee-jerk vote in the sense that the decision, the Ponence's recommendation was to give the land to the government. My knee-jerk reaction is, if it goes to the government, then no, that's fine.
Okay.
But I realized that later on, why are we giving it to the government? The government did not claim it. The government claims that it already sold it to Manotok. So even now, problems are rising concerning that because Manotok has sold some of the properties to others, and now the government will be the owner of this property. It's really a problem. That's why I changed my vote.
Okay.
I think, I don't know if I'm the only one that changed my vote because I saw the wisdom of the other vote.
Okay. My last question, Justice. So, if you will be appointed as the next Chief Justice, what is the one important legacy that you wish to leave after leaving the court?
Well, I should be the Chief Justice that change a lot of things. Because I want to change a lot of things.
Can you name a few
Well,
of those things which you
So
want to
change
change?
congestion and all those things. And I have many other projects, by the way. I was speaking to Secretary De Lima about this problem. Because, you know, we have so many criminal cases. About 50% or more of our cases are criminal. The reason to that is that about 30 years ago, I don't know if you remember, you can file a case in court, Bureau Fiscal, if there is prima facie evidence. That's somewhat a higher level of evidence. But for somehow they change it to probable cause. Probable cause is just a belief.
Yes.
And do you know how far away probable cause from proof beyond reasonable doubt? It's so large. See, that's why many fiscals are telling me, or judges in, or fiscals in Laguna, or some of my friends there, they told me that in some of these drugs cases, they know that the investigator is lying because they use yung mga standard, what do you call that, the standard facts that he dropped it, he saw it, and all those things. He saw him carrying it. They have some very standard. They use even the template of the previous affidavits. So they know that the case should not be filed. But the police officers would say, but Your Honor, if our affidavits contain all the elements of the crime, you have no right to dismiss it. That's true. So they have to file it. So Justice, the Secretary De Lima, we somewhat agree that we will next time, I hope soon, we would like to raise the standard for filing cases to a higher level. Let us say clear and convincing evidence. We will not file it without prejudice to your giving us better evidence. Then that we're going to file it. Otherwise, it will not go to court. The other thing that I suggested to her is that we should give the plea bargaining job, remove it from the court, and give it to the fiscal. Because the fiscal can negotiate with, you know, you have the evidence, we will ask for maximum penalty for you, etc. So you have the chance, you can plea bargain. But if you do it with the court, Especially, it's compulsory for the complainant to be present. And the wound of the complainant is still fresh. If you say you propose plea bargaining, he say, I will never agree. And then 5 years later, when still coming back to court in the case that decided, he would say, I wish I had agreed to that plea bargaining, has gone to jail already. See? So that's some of the plans that we have in the United States. It used to be only 50% of cases filed with the district attorney's office go to court. Today, they tell me, one of the American lawyers was consulting with me, told me that only 3% of cases go to court. You know how it will unclog our dockets?
So that's a very good idea.
Yes,
Thank you very much, Justice. Good luck.
Justice Hermosissima.
Good morning.
Well, in that connection, when Thomas Dewey was of the United States was the prosecutor in New York, he had a 100% conviction
Yes.
because he would not file any case which is not which is not strong.
That should be the case, Justice.
Now, there are many sectors that would prefer that we abolish the bar examination. Instead of that, they propose that examination should be made of every year, first year, second year, third year, fourth year. In that case, if a student is not capable and during the first year, he can be eliminated. Second year, the same thing until the fourth year. And you see what's happening now. Only 20% in the average pass the bar. What happens to the 80%?
25%, indeed. 20%.
What happens to the 80%? They're jobless.
Now, some of them become police officers and legal researchers. And
So, I think the idea is reasonable because that will eliminate the students who are not capable of being lawyers. What do you say to that?
well, Your Honor, there's a public interest in having only capable lawyers qualify. The function of the Supreme Court under the Constitution is to manage the admission of lawyers to the bar examination. And actually, I can compare the role of the bar examination as a final check. Like, for example, in a big garage of taxis, you have somebody there at the gate before the taxis goes out to check if all the tires are okay. The engines, the wiper, the doors are closing, and before it goes out, because it will render public service. It should be safe. It should take the passengers to where they want to go. So there's a final check. We are not involved in the production line, no? Or what the cars they manufacture, etc. But we are, certainly our role is to protect the public. But if we follow that suggestion, Your Honor, please, with due respect to them, what will happen is that it will be the schools who will really decide whether they will become lawyers or not. And as you know, not all schools have the same standards of instructions. I wish they have. The court will give the exams. Every year, the Supreme Court. Well, I think that's also possible, except that will be entail a lot of work. What I was suggesting is we give an exam on the second year. Well, that's something that just crossed my mind. We give the exam on the second year after the basic subjects. And then after that, we will determine whether they can already proceed or not. Then after they proceed, we can have just oral examination, interviews, or something like that to see whether they're qualified. In other jurisdictions, they require apprenticeship. Because, you know, if you throw the lawyers out into the open and he has not handled the case, he can send people to jail or lose a lot of money because he's not yet trained. In Japan, you have to pass through a rigid apprenticeship and then you are allowed to go. That way we protect the public. No, it's the public interest that we are after.
Another system is you only have at least one law school for all. Like in Hong Kong, for example, there are very few lawyers because only lawyers, only students of law who go to London to study law will be
yes.
admitted.
I suggest Ateneo and UST, Your Honors. I did not study there. No, I'm just joking.
Cases which are not necessarily decided en banc are decided by a division of the Supreme Court.
Yes, Your Honor.
The decision of the ponente in that division is considered a decision of the whole court.
That's true.
There are objections to this manner of deciding cases because it is felt that the decision of a division is not a reflection of the sentiment of the whole court. What are your thoughts on this matter? Would you agree that the cases be decided en banc instead of by division?
Well, I may just say that if it is by just one by the en banc, then you are going to have only one functioning body. With the divisions, we multiply our production 3 times. And as you know, as I said, how many cases are we getting every year? Maybe about 5,000 cases. So
one point is
very
that
difficult for just one body. It will be a very small, what do you call that? A very small hole for a large amount of data or cases to come in and not get through. Then we will have problems.
In the United States, for example, there are only cases that go up to the Supreme Court only consist of 100.
100 cases. Yeah, I agree.
100 per semester.
I agree. Yeah.
Because the cases that go up to the Supreme Court are limited only to constitutional issues. Now, what do you say to the practice now in the Supreme Court, which says, well, only questions of fact, of course, only questions of law are supposed to be attended to by the Supreme Court. But why are we accepting cases where the appeal is only on questions of fact? If we stick to that proposition that only questions of law shall be entertained by the Supreme Court, then the cases that go up to the Supreme Court will be limited. Can you imagine that if you must have learned that even ejectment cases reach the Supreme Court?
That's true. Well,
That's why there is a proliferation of cases in the Supreme Court.
Well, Your Honor, the jurisdiction of the Supreme Court is somewhat very broad. No? Maybe if we can amend the Constitution and really limit it, well, that will be fine. What is more, our lawyers have a tendency to go up to the Supreme Court from the Court of Appeals. Although they have very little chance. There's just a small window for them to get through us, actually. I wish you could give us, we will have better time in the court if we will be like the U.S. Supreme Court. But that's not the problem. We are not only a constitutional court like that of, let us say, Korea. They have a constitutional court. It does nothing about constitution. And they have a higher court that's not hindi constitutional. Maybe we should have two Supreme Courts. One constitutional court, then that's limited. And the other one is appeal from the Court of Appeals and other actions.
You can recommend that to the Constitutional Convention.
That will spend more money for it.
Justice, do you believe that there are many provisions in the Constitution that need amendment or revision?
Well, the economic provisions there about the amount of the investments that foreigners can make. Actually, tayo na lang yata yung...
Well, there are three ways of amending or...
and then the possibility of making a...
do you agree to the convening of a constituent assembly to amend the Constitution instead of a constitutional convention?
I don't know if a case will come up to the Supreme Court on that. So sometimes I'm reluctant to give an opinion that may, I have not heard all the sides. That's the danger of us making a statement now on a certain position that I've not really studied well and have not heard both sides.
Well, thank you very much on that note.
Congressman Topas.
Salamat. Thank you, Mr. Chairman. Good morning, Justice
Good morning
Abad.
po. Good morning po.
Kasi, sa lahat ng miyembro ng present members ng Hudikatura, dalawa lang yung nakakausap ko di ba? Yung una nakakausap ko yung dating Chief Justice dahil kasama ko sa JBC. At yung pangalawa, si Justice Abad po dahil dun sa reforms na ginagawa natin para sa Hudikatura na sinusuportahan naman ho namin sa Committee on Justice.
Thank you for remembering.
Kaya kilala natin si Justice Abad at isa sa mga may respeto ako na miyembro ng Korte Suprema.
Salamat.
So good morning to you, Justice.
Salamat po.
Konting katanungan lang po. May mga sektor kasi nagsasabi na napakahirap para kay Pangulo na ito yung isa sa mga desisyon, hindi lang sa JBC kami, kundi pati kay Pangulo, na mag-appoint, kung sinong i-appoint niya na Chief Justice after nung nangyari lahat. Kasi napakataas nung expectation. At merong grupo na nagsasabi na bakit hindi natin gawing compromise kandidato natin si Justice Abad? 68 years old. 2 taon lang maninilbihan. May mga reforma. Siya yung parang mukha ng reforma rin sa Korte Suprema. At para after 2 years, another Chief Justice. By the time, baka parang nag-mellow down na rin yung mga nangyari, di ba? So, ito, naririnig ko lang ito, Justice, di ba? Kaya parang, para sa akin, you're a serious candidate for the Chief Justice position. Ano masasabi mo nito sa sinasabi nilang sa sektor na yon na nagpupush sa'yo based on those arguments?
Parang wala ako kung masabi dahil hindi ko actually naisip. Ang naisip ko lang is, sabi ko nga kanina, parang mas mabuti yata kung tigaloob. Dahil kung tigaloob, kasi kung tigaloob, parang magkakaroon ng renewal within. If the President appoints an outsider, nasugatan na nga ang Korte Suprema, parang isinubsub mo pa sa lupa.
Again, kung sa labas kukuha,
Kung sa labas kukuha, parang you don't trust those who are already part of the judiciary. So parang inano pa sila, no? Pero kung nasa loob and somebody with the mind to forgive, as I was saying kanina, wala ho kayo, na dapat maging gagawin ng Chief Justice dito is to forgive. Forgive the President, forgive the Congress for the hearts that we have suffered. Not only because of your action, but because the press that
patawarin niyo po kami.
Patawarin.
Sa
At
ginawa
kayo
namin,
din,
ano po ginawa namin?
At kayo din po ay patawarin niyo kami. No? There can be no healing of wounds unless there is forgiveness and of openness to reconciliation. No,
Okay.
not necessarily that what you
Okay.
did. No? I think you did your...
Pumunta ho tayo doon sa wounds na sinasabi nyo. So may mga sugat. Diba? Personally po, sa nangyari sa pagpatalsik kay dating Chief Justice, personal na pananaw nyo po. Una, sa Korte Suprema at sa Hudikatura, healthy ba yon ang nangyari? Pangalawa, naging healthy ba yun doon sa three great branches of government na relasyon? Executive, legislative, and judiciary. So una, yung pagpatalsik ng Kongreso, impeachment namin at verdict ng Senado. Personal na pananaw nyo, naging healthy ba yon dun sa inyo po, sa Korte Suprema ngayon at sa Hudikatura?
Well, healthy dahil it wakens us, ano? It makes us consider where we are, no? It makes us look at our inner being, our conscience, determine where we stand. It's somewhat disturbing.
Naging mabuti ba?
Well, in that
naging
sense,
mabuti.
Mabuti yun, no? Because, if you pass through a crisis, that really makes you a better person. You
Okay.
acquire better character.
Okay, how about doon sa sistema nating tatlong systems ng checks and balances? Naging mabuti ba itong nangyari? Sa inyong pananaw lang, personal.
I was not, hindi ako nanood ng impeachment trial. I did not see the evidence. So I cannot really honestly say whether you made a correct judgment or not. So
No.
That's
Mike,
something that I...
Justice, hindi kita tinatanong kung may correct judgment or not. Ang tanong ko lang, yung
as
buong
an
system.
exercise, yes. As an
So, naging
exercise.
mabuti po para sa
Yes,
inyo?
Yes, as an exercise, because it shows where we stand. I think it's the first time we have an impeachment proceeding like this. So it is a healthy side. Only, we lost a friend. He's our friend in the court. He's been with us. In a way, you'll understand even if you have friends in Congress whom you lose either through death or removal or recall or whatever, you feel a little sad about it.
Ngayon po, Justice, kasi kayo unang-unang insider, di ba? Yung term nyo kanina, na incumbent na Justice. Kayo yung unang-unang nakasala ngayon.
Oh.
Di ba? Kaya gusto ko lang tanungin rin sa inyo, kasi hindi namin alam na yung nangyayari talaga sa Korte Suprema.
Sige,
may mga nagsasabi na yung present ngayon na Korte Suprema, at least nung during the time of impeachment, may mga grupo-grupo dyan. Parang sinasabi nila may groups. Totoo ba yan?
Hindi siguro totoo yan. If you examine our voting records, iba-ibang voting records, even where the Chief Justice take a position, he loses. There are a lot of cases I can cite to you where he...
So independent yan. Ibig sabihin yung 14 at yung isang Chief Justice.
I think so, yes.
So walang grupo yan. Walang parang Congress na Liberal Party, NPC, pagbotohan. Meron ba ganun talaga po?
No, I'm not...
Wala po.
No, I will dare say there's none.
Okay, sige. Clear po yun.
There's none, yes.
Ngayon po, yung SALN po, di ba? SALN. Yung SALN, yun yung dahilan ng impeachment. Akala ko nga, ipapahuli namin, pinauna na rin namin yung SALN. Dati kasi, yung Congress, with all the criticisms na natatanggap namin, nagre-release kami. At least, may summary kami rin nire-release. Alam nilang worth ni Congressman Tupas or ex-Congressman Y, Speaker Belmonte, alam ng tao. Pero ang Korte Suprema, until the impeachment, wala po kaming alam. In fact, nakuha lang namin yung copy nung SALE, nung day 3 na ng trial Diba? Bakit nag-change po yun? Bakit parang after impeachment, ano po yung naging dahilan na bakit after impeachment pronouncement ng Korte Suprema?
Well, nung una, I think 1995 or during the time of, hindi ho ako or kami, the present court, decided that the SALN will be withheld. I think they have a reason. I think even the President recognizes that certain instances, some portion of SALN should not be revealed to the public. Parang meron ganun na some of the wealthy ones, they don't really have to reveal details or something like that. Maybe the old justices, they had that concern. But they did not really absolutely prohibit disclosure. You have to ask for the record and you have to have a valid reason. I think that's a good...
Justice, alam na rin natin yun, di ba? Alam na natin yung...
Now, we changed. You asked me why we...
Yes po.
We changed.
Bakit nag-change po?
No, even individually, many of us says we should reveal. We have nothing to hide. We could show
Pero bakit
our
after
son.
impeachment po nangyari yun?
Because that is the time when we are not just alone. This opening up of the son of the members of the judiciary affects even the lower courts and the other appellate courts. We have to do consultation. We are a democratic institution. So we did the consultation, and after that, at our, even among us, the vote within our court is unanimous for showing this. It's only because this came up because of the impeachment trial. Nobody ever really complained to us in a way.
Ako po nakita ko na yung SALN ninyo, di ba? Ngayon, nakita ko na. Nakita na rin namin yung SALN nung at least yung 5 pa. Ito ba alam na ng publiko rin? Because of that decision, binibigay na rin sa public.
Yes, I think so. Although I think we have some rules to prevent what do you call that, yung talagang people who make a nuisance or things like that. You just have to show you're a press, member of the press, and you get it. You get it.
So pwede na po?
Oh, yes.
Lahat ngayon? Open na talaga?
Yes.
After impeachment?
Well, after the impeachment, yes.
Okay.
Because the court reconsidered the 1995 rule. We have a rule of law also. No? So I was bound by that. I'm not going to show my Salan even if I wanted to, because we have this rule passed by the Constitution by the Supreme Court that was never reviewed because there was really no
so transparent na talaga ang Korte Suprema as far as that is concerned, di ba? Transparent.
I think none of us is anything to hide.
May tanong lang po ako, yung pinapatanong lang sa akin. Nung time raw nung impeachment, isa po raw kayo yung palaging kasama sa misa dito, para may mass, di ba? Hindi ko lang alam kung in support of personal support yon or institutional support, di ba?
Personal support, because he's my friend also. We've been together in the Supreme Court. I'm loyal to my friends.
So personal po
It's
yun?
a personal, purely
Yung,
personal.
let's say yung pagbisita rin sa medical city, that's a personal.
Yes, of course.
Pero hindi nyo na, kahit po yung suporta nyo sa kaibigan, hindi nyo rin po,
Well, I did
hindi
nothing.
na yung patingin nyo rin sa buong sistema.
Of
Na-affect,
course.
iba yon.
Of course, iba yun.
Okay,
I will, I'm one person who does not, who does not discard a friend when he's in trouble. He was my friend. He helped me as a senior justice. He helped me learn the ropes. And
loyalty
I consider
to a friend, yun po yan?
To a friend, but of course not.
Yeah.
If I am not going to betray the institution. It's purely
a friend.
Yes.
Okay. Justice, last question na lang. Justice, kung ano yung katangian nyo na, isang katangian nyo, for example, na makukonvince nyo kami lahat na ikaw yung unang-una sa listahan namin pagdating ng Lunes sa botohan. So anong katangian po yun? Isang katangian lang.
Well, I have passion for the things that I want to do. I think that's something. I'm not really workaholic like Justice Carpio or Justice Brian. Oh, they really work very hard. I don't like work, but when I have an obligation and a commitment, I really work. I really work because of that.
You can lead the Supreme Court as Chief Justice. better than the previous one.
I don't
Definitely,
want to say that. I don't want to say that.
Because of a friend.
No. I'm not to judge just... Well, I'm afraid I don't want to judge the performance.
But you're confident, Justice. Let's say,
Well,
2 years ka lang.
God's
Kasi
help,
magiging
I
less
can
than
do-
2 years ka na lang eh.
Yes, yes.
Diba?
Yes.
Pag ikaw ma-appoint, and I have high respect for you, Justice. No? Sinabi ko na kanina. Ikaw lang nakakausap ko sa membro ng Korte Suprema. Less than 2 years lang ito.
Yes, because
so sa less than 2 years na yon, marami ka bang confident ka
Oh, yes,
to lead?
because as I told them, in the last 3 years that I've been here, I've been working on those reforms already. And they will take place in the next 2 years. And the others that will not take place in the next 2 years will be harvested by the future, by our children. That's what I plan to do.
Okay. Salamat. Good luck, Justice. Thank you so much.
Secretary Mejia. Secretary Mosmi. Sorry.
Magandang umaga po, Justice.
Hi.
Your Honor. My first question, Justice, is if the President should choose the next Chief Justice from within the present roster of the Supreme Court, why should the Chief Executive choose you over the most senior Justice of the High Tribunal, do you think, who is also now the acting Chief Justice? I think you have mentioned some highlights and answers in previous questions, but I think this is an important question to underscore, so I'm asking it again. Your views, please, Justice.
That's a difficult question in a sense because I'm going to have to compare myself to others. When I've not really heard, I'm not privy to their qualifications or their experience or things like that. So I'm afraid in that way I cannot answer it. I can only say that like any of them, I have the determination to accomplish whatever I set my vision to. Do you know the Chief Justice wears two hats? One is that he presides over court that decides, make decision making. And then he must have comprehensive knowledge of law and the ability to focus discussions and issues, to be able to identify the issues, to try to build up consensus, but to protect those who disagree. That's one of the things. The other function of Chief Justice, the other hat that he wears is that of Chief Executive Officer, CEO, because he runs a big organization. Some suggest that he has to be a business manager. Now, actually, any smart lawyer can cite principles of management from the textbooks, but I don't think that's really necessary. We can hire, as a matter of fact, we have consultants and we have experts on running things. But what we need really is a Chief Justice with a vision and a determined to reach that vision. I hope you will look for a justice like that, not necessarily myself, but somebody that you feel has a vision and will reach for it.
Thank you, Your Honor. Sa palagay niyo po, meron ho bang nakakaligtaan ang public, ang masang Pilipino sa kanilang palagay tungkol sa Korte Suprema? What do you think are the root causes of the perceived lack of trust in the judicial system in general, in the Supreme Court in particular? And siguro tuloy-tuloy niyo na po yung sagot. Ano hong tingin ninyo ang magandang solusyon para dito?
Well, I think we get plenty of bad publicity from some of our cases. But in the future, I think the court has to sit down and, the Chief Justice should be able to bring them together to come to certain agreement. One of the proposals that I make is that we have so many cases. One of the proposals I make is that we be careful in making our decisions. And we can do that because we cannot guard everybody. We have 3 divisions, and sometimes we come up with conflicting decisions. So I go for really important decisions, really doctrinal setting decisions. But what do we have? We have, when you open this CRA, you discover a lot of unjust dismissal cases, halos 1/4 of the book. And then sheriffs who marketed money, clerk of court who malversed funds, rape cases. This is what you find in our... so I suggested to them that we, what do you call that, screen the decisions that are really important and pay more attention to them. See, and just dispose of the others by memorandum decision, so that we are not unduly creating disagreements in various cases that we have. But it's still something that we debated over it last Tuesday, you remember, because I am the advocate of that position, that we should be more careful in our decisions to avoid, as I said, that perception that we flip-flop or things like that. But you know, in that flip-flopping case in the cities, there's nobody really out of... Yeah, it so happened that cases was taken up when 7 justices left the court. So the new justices that came in, they have their own views. So since the balance of votes were somewhat close, just a few of those incoming who have different views will tilt it to the other side. As a matter of fact, there's actually only 2 who changed their vote, and not flip-flop. They just changed it once. The others, I think there were many justices who voted it. None of the others, maybe 17 justices, because there were changes, ever changed his vote. So it's a lack of what you call the understanding of the way of what happened there.
Thank you po. If I may, Justice, I'd like to ask you one question that is close to my heart. One is, I think I have been extensively answered by you, and that is about the delay in the administration dispensation of justice. Just to follow up on that particular point, ano ho ba ang konkretong magagawa ninyo para mapabilisan ang paglitis para sa mga akusado sa kriminal na kaso upang mawalan sala at maabsuelto ang hindi naman talaga may mabigyan katarungan ng hindi may kasalanan sa mabilis na paraan ayon sa batas?
Well, yung nga sinasabi ko, we will change from the very slow adversarial system into the combined adversarial, etc. Now, in the criminal cases, actually, I have the problem there is that our jail are congested, and the case is not being tried fast enough. What we did together with the International Red Cross is to establish in Manila, first as a pilot place, we established there a task force Kalayaan that will monitor the cases, the criminal cases, to make sure that they move, and to make sure that those who are held in court, what do you call that, unduly for a long time, are going to be freed. For example, we have a prisoner in Manila that has been there for 17 years. Imagine, 17 years. His case has not been finished. I was going to call the judge and tell him to dismiss that case if it's not been, that's already patent denial of right to speedy trial. Dispose of it, or I'm going to file an administrative case against him for that kind. And the problem in our country is that our bail system is anti-poor. I don't know if you realize that. It is anti-poor. Why? It is the Department of Justice that sets the bail band guide. And I don't know why the judges follow it as a rule. The judges will reduce the bail only if you pay cash and then one half cash, then you will be allowed to go. But who can pay cash? Only yung mayaman. Based on the bail band guide, if the owner of the mall and the tricycle driver commits the same crime, who do you think will stay in jail while the case is being tried? The tricycle driver. You see? And we have no right to treat the poor like that. We are working on it.
I agree with you completely, Justice. another very important topic for me, Justice, Your Honor, please, is trial by publicity. Can you please explain very briefly your views, if there are any, if you agree that it has pernicious effects in the administration and dispensation of justice? And what mechanisms, if any, do you think are very important to shield the judicial system from...
Well, I don't know. No, you have
this?
to... That may come to us later on. No? So it's difficult to say, to take a position, but I'm somewhat a liberalist in a sense. No? Well, not too extreme. So there's the freedom of the person on the one hand, and the other hand, there's the... You have to protect the accused, because the judges will yield to probably to the public opinion. Although I doubt that, you know, because maybe a jury, because the newspaper, you will be influenced. But our judges somewhat are professional judges, by the way. And it's good you remember me that we don't have a bad court, really. You know? I think 80% of our judges are doing very well. Some of them die on their work, you see.
Chairman, if I may, just one last question. As a final question, Justice Abad, what is your concept of the rule of law? How do you envision it in the sphere of having a judicial philosophy, if I may ask?
Well, I'm really for the rule of law, as you all are. We are all for the rule of law, because we have rule of men, magulo tayo. You see, so we really have to have, everybody should obey the law, no? Sabi ni Mayor Lim. Otherwise, it's useless to have law. Congress should have no more job, and everybody will decide cases from disputes from case to case. So we have to have rule of law. But we should interpret the law to serve justice. That's what I mean. No? That in that sense, I will go for putting the human considerations in the interpretation of the law.
Just one last follow-up. Rule of law and the sovereign Filipino people, who do you think is supreme?
I think they're the same, because law comes from the people indirectly through the elected legislature. That's my answer.
Maraming salamat po, Justice.
Salamat.
It's a pleasure asking questions from you.
Thank you.
I don't know if I will ask questions. Because,
Don't ask me difficult questions.
No, anyway, for the information of everybody, Justice Abad and I sit in the same third division. We've been there for the past 2 years. I know that Justice Abad is very much qualified. I confirm what Justice Lagban said, that he's an innovator. But I have some questions to educate the public how we work in the Supreme Court. Now, aside from your adjudicatory functions, Justice Robert, what other functions do you perform?
Well, I'm quite busy in committees. Well, after 1 year, I asked the Chief Justice. We have no committee like this, you know. I asked the Chief Justice to create a committee to address case congestions and delays, and I volunteered to work on that. So I'm working on that.
Sa madaling salita, bukod sa adjudicatory functions ng Justice, ng Korte Suprema, meron kanya-kanyang committees.
Meron. No.
Bukod sa member ka ng committee, meron ka rin yung committees where you chair.
I think you sit in a lot
I'll
of
go into that
other
now.
committees.
And you chair the Committee of the Internal Rules,
Yes.
where yours truly is a member. No?
Yes.
You also sit as a chairman of the committee to draft the rules for pilot testing in Quezon City,
Quezon City, correct.
how to dispose of cases, and you invited me also as your member. Aside from these two committees, you're also a member of what committee?
Jail decongestion.
Jail decongestion, and the other one is the Ethics Committee.
Ethics Committee, yes.
Okay, so you have 4 committees where you're a member, 2 of which you are the chairperson. Now, ang tanong ko po ay ganito, iting committees nito, ano ang role ng Chief Justice? Ang Chief Justice, hindi siya chairman of each of these committees, hindi ba? Yan tanong ko ngayon, because he's not a member of these committees, ano ang role ng Chief Justice sa committees na ito?
Ang role ng Chief Justice, it is that they produce. That they just don't just hold committee meetings and what they would do end up in the files, in the cabinet. But the role of the Chief Justice is to ensure that they have result and people move to make these things happen.
Yeah. I think you also sit as a member of the committee of the revision of rules of court, the mother committee, which we call the mother
Rules of
committee.
Civil Procedure. I'm also the
No,
chairman.
in the mother committee, it's
Yes. I'm
it
also a
is,
member of the mother
yeah.
committee. Yes.
The mother committee is actually the committee on the revision of the rules of court,
Yes.
which is chaired by the Chief Justice.
Yes.
Yes. And you sit as a member of a committee or a chairman of the committee that drafted the rules for pilot testing in the RTC of Quezon City. Okay. Now, whatever we took up in that committee, then the draft rules forwarded to the mother committee
Yes.
because it might affect other provisions of the rules of courts,
Correct.
which might be amended or in
Correct,
conflict.
correct.
So we bring the rules
That's true.
proposed to the mother committee.
That's true.
And the mother committee is chaired by the Chief Justice.
Yes.
So the Chief Justice should know what are these proposals are, because there will be as we always have, there are healthy debates, no? And the members of this mother committee are not only justices or incumbent justices from the
Outsiders,
Supreme Court.
yes,
Yes,
outsiders.
there are retired justices like
That's true.
Justice Vito, Justice Ascona,
That's true.
Justice Callejo, and we have representatives from the private sector. I remember Attorney Francis Lim,
Yes.
yes, on commercial law. I think he was representing the private sector, yes. We have also Dean Cesar Villanueva, I
Yes,
think so.
Yes, yes.
And our consultant in the rule and evidence, Tony Rolly Binuan. Okay. Then we discussed the proposals, no? If the proposals are approved by the mother committee, that's not the end. It will go to the en banc.
Correct.
And then as you as proponent, you will now present your proposals in the en banc session, and then we will have another debate among the justices. Yeah, that's what actually happened.
But you know that's where the leadership of the Chief Justice
Yeah,
is important.
that's what I'm asking.
Yes.
The en banc session is presided by the Chief
By the
Justice.
Chief Justice.
There will be a lot of inputs coming from the other justices,
Yes,
and you will find some resistance.
Yes, that's
okay?
correct.
Yeah.
We have a very cynical, some cynical members there. I recall.
But not Justice Peralta, of course.
Not just- No, I recall that during the time of Chief Justice Puno, he got these various writs through, and the small claims court
Rules.
fast because he put his what do you call that? He put pressure on it. He really made sure that it is done
Yeah.
immediately.
I remember because that was his vision.
Yes, yes.
He wanted to
have these things.
apply the provisions of Article 12, Section 5, Paragraph 5, on the rule-making power of the Supreme Court.
Yes.
And he wanted to come out with rules for the protection
Yes,
and
the environment
enforcement,
and all the other
constitutional rights,
Yes.
which are, human rights, which are the writ of amparo and writ of habeas data. Then you have the civil rights for the poor, the small claims. And then the other one is environmental rights, which we now call the writs of kalikasan and the other writs, no?
Yun ang vision niya.
Yan ang vision niya, which he achieved
And
before
he
retired.
worked on it, really.
Yeah, he worked on it
He
and
supported it.
And he saw to it that before he got out from the court, these rules are
Binraso
adopted.
niya. Binraso niya to get
Talaga,
it through.
talaga.
And you know, we profited from it also. You have to need that
Talaga, brinaso niya. I could remember Justice Robert when...
And pleasantly, pleasant
talagang binraso
saying
niya.
the binraso. But actually, there was consensus.
Yeah.
But he insists that decision be made immediately.
Mahirap talagang Chief Justice, hindi
Correct.
po ba?
Yes.
No, I remember when we were preparing the rules for procedure for environmental law, we would meet on Thursday from 8:30 in the morning up to 5 o'clock for 1 year.
Because he wanted it through. He
He
insists that it be finished. Well,
The-
that's what.
And you remember when
we have a
the
Chief Justice there.
that's only one part of the job of an associate justice, no, and part of the job of the Justice Supreme Court. Now, my question is, do you agree with me that there are many cases that are placed in the agenda during en banc? I think it's something like 300 to 400 cases. Every Tuesday.
Every Tuesday, correct.
You have around 200 judicial matters, probably. The other 200 would be administrative matters, cases filed against lawyers, cases filed against judges, and then the other matters like budget, building of a hall of justice. Where will we get the allowances for our employees? What shall we do? Shall we talk to the congressman so that something is inserted or something is amended in the budget?
Talk to him.
The judiciary is only getting less than 1%. No? Shall we continue with the implementation of RA 9227 in order that the judges and justices will still enjoy the SAD's allowance? Many things, sir. Aside from, and it is presided by the Chief Justice.
Correct, that's true. It's
What should
really a
they-
tough job.
Yeah. It's really a tough job. Not only that, if you are an associate justice, we have deliberations on Monday and Wednesdays, and we have cases placed in the agenda on Mondays, and also cases placed on the agenda on Wednesdays. And you know how many cases are placed in the agenda? 300 to 400 cases on Mondays, and 300 to 400 cases on Wednesdays. And we deliberate on Wednesdays. Can you explain how
I've
we work?
never worked so hard in my life.
Yeah.
Well, if you're serious with your job,
Yeah, I'm asking you these questions so that the public may know it. No? That the Supreme Court is a collegial body. We respect the opinions of everybody. No? All the opinions are placed on the table. We discuss. Sometimes there are extended arguments. Sometimes we cannot arrive on a consensus. Then we have to reset. Somebody will ask for another month, and so on, because of the delicate issues that might be raised in all these sessions. And can you imagine if the presiding justice is maybe experienced in the law but has no experience about all these matters that they're taken up in the agenda? Do you agree with me, Justice Robert?
yeah.
Huh?
Well, even if we have a new Chief Justice from the outside, he will eventually learn the ropes.
Yeah, but
the
it will-
important thing is that he has that kind of personality, ability, character that will, so that he will gain the trust of his colleagues, even if you're an outsider.
Yeah, that's
That's
correct.
what's important.
That's correct. But when you want to gain the trust of your co-employees, then you must be somebody really who is.
Yes, you must be really.
You must be above.
You must
everybody.
really have it. Yes, that's correct.
You should be above everybody. You know. Now, you are only one of the 5 or 6 applicants, no? And you said, you confirmed what I said, that you are members of several committees. Justice Brown has also committees. Justice Tess De Castro
that's
has
true.
also a committee.
That's
Even Justice Carpio has also a committee. All of us have committees, no?
That's correct.
Yeah. You can just imagine the so numerous committees that we have, important committees.
Para tayong
And,
Congress, marami tayong committee.
minsan pa parang mas mahirap pa eh. Di ba, you told me once mahirap pa tayo ito napasukan ko. I think you said when you were
Yes, that's true.
starting.
I think I was happier when I was in private, in the sense, in sense of comfort, etc. But I find a challenge to this job.
Now, do you agree with me one of the reasons why mababa ang rating, Somebody suggesting that sometimes we ask questions in Tagalog so that everybody understands.
Oh, sige.
Yung cross-rating kasi ng Korte Suprema, ang kaso ay dalawa parating parties involved eh. Meron nanalo, meron natalo. Eh kung sinurbay mo yung natalo, anong sasabihin nun? Eh siyempre, masama. Ang sasabihin nun, nabayaran yung judge eh. Yes. Kung hindi naman, as an excuse, forgive me if I say this, pag natalo, sasabihin ng lawyer
Nilagyan.
lawyer paano yung kabila naglagay di ba? Sasabihin sa kliyente. First naman dito, I'm not saying you do that Nandito si Attorney Cons from the from the impeachment court di ba? Nandito private prosecutor. Kaya mababang trust rating Meron parating natatalo eh, hindi ba?
Well, meron ding valid reasons sometimes. No?
Yeah, but there are valid reasons. But one of the reasons is that unlike legislative, yung law for everybody eh. If they do not like the law, then they can challenge the constitutionality or legality eh. Dito maglalabanan sa Korte Suprema eh. Dito, pag natalo yung kliyente, walang ibang magandang rason eh. Paano, nabayaran ng ganito? Hindi marunong yung judge. Yung judge, in-appoint kasi, bago-bago lang yun eh. Di ba? Bata pa. Things like that.
Yes,
You can just imagine when the survey is made and you ask the questions from these people, trust rating natin talaga, bababa. Hindi ho ba? Justice Robert?
Oh, pero parang nung panahon ni Chief Justice Puno, maganda rin ang trust rating, ano?
Oo, maganda ang trust. Mataas ang trust rating.
Siguro ang perception, siguro depends on a lot of factors, ano? Well, we have to clean up, the court. But I was talking to Ruan Libarios, and I was telling him, we have to put our acts together in the matter of corruption.
Yeah.
It is not as if the standard or conventional remedy is detect, investigate, prosecute, remove. But we have that in the past many years, and it has not really worked in a way. What I was looking at, I was listening to Tony Kwok of Hong Kong, and I think I agree with him, is for us in the legal system to come to an agreement. One day, beginning on this day, we will clean up everything. We will we'll have dialogue with each other and say that honesty works. There are law officers in this country who do not give bribes and they prosper. And there are judges who have happy family lives with their salaries. They have to develop that kind of thinking, and for us to be jealous. In the United States and other places where they don't even talk about corruption in the judiciary, US, Australia, Singapore, Japan, Hong Kong, they don't even talk about this because takot sila their bar is so strict. No? If you commit something wrong, you're out. You're out of the profession. Sometimes I was telling that we will not receive bribe if nobody will give us bribe. See? So we have to come to, well, that's what I think, we have to put our acts together, talk to businessmen, to tell their lawyers not to give money.
Yun kasi ang problema. There is no bribery if there is no giver eh. May nagbibigay kasi.
That's why,
wala nagbibigay, walang bribery.
But they were able to overcome that problem in these countries that I mentioned. They had briberies, these countries.
Yeah.
But they had that kind of leadership that brought people together and says, we have to clean up because it's our children who's going to live here tomorrow. Two of my kids are living in the U.S. already because I felt when I was in practice that things are not so good.
Probably they will come back when you're appointed Chief Justice.
No, they have families, they have worked there already. But what I'm saying is this, that we can always that as a remedy. Some of our grandchildren may not have a congressman for a father. Some of them will not have a judge or a lawyer or a justice. And they're going to have the same fate that common people suffer. So we have to make justice available to common people. We have to remove corruption so that our children will not be victims of corruption. We have to decide on it.
Meron pang tanong dito, babasahin ko ito. Is a question, baka sabi nila, ay hindi ko tatanungin kasi baka hindi maganda yung tanong.
Di bale. Hindi ko sasagutin.
There is a question here. I cannot actually understand the question, but it's something your relationship with ex-Solicitor General Mendoza. Probably the second question and the third question should be asked together. Ang sinasabi kasi in the question, your relationship to Solgen Mendoza, and that how come that a letter from him could reach the en banc and consider this as a pleading, something like that. Like in the case of probably he's referring to The questioner is, I mean, the one who posed the question is, you might be referring to the PASAP and the League of Cities, and then your relationship.
Well, I was not involved in the FASAP case, so I think it's belonged to another division.
Yeah, I think.
Okay.
Now,
Well,
just anyway,
my relation to him is that I worked for the Solicitor General's office 11 years. And actually, I was solicitor, I was not reporting to him directly for 10 years. I was only reporting to Justice Vicente Mendoza, who was my head, and then later on some other Assistant Solicitor General. And on the last year that I was Assistant Solicitor General, I reported to him directly. But we have become friends because that's what we have. And the people we work with, they become our friends. But I never worked for him.
I can confirm that in one case where I was the ponente, the decision was adverse to the client of Justice, of Solgen Mendoza, and you joined me. You remember that case about an arbitration?
I don't remember. Exactly.
But anyway.
I don't remember because I don't look at the names of the lawyers actually in the cases. That's something.
So for your information, you joined me. It was a decision. It was a decision adverse to Solicitor General Mendoza.
I practiced for 22 years. I never practiced with him. I have my own practice, and I think I can be proud that I have a prosperous practice when I practice. I did not need cases from him. The only time I appeared with him was in that tax case where he was the lawyer for Fortune Tobacco and Lucio Tan, and they needed a lawyer for the distributors. They were looking for a lawyer. He recommended me, so I accepted. I accepted that, and that's where. And the test of whether I did anything wrong is to look at the evidence in that case. Whether I introduced evidence that is false or made any misrepresentation or things like that. No, I did my best as a trial lawyer, and I was paid for it.
When you won the case, I think your clients were acquitted.
Yes, I won the case.
Okay. Now, this is also a question. How will you bring back, I think you answered this already, how will you bring back the public trust to the Supreme Court? I think you already answered. There was a question asked from a member of the panel. Okay. I think that's all, Justice Robert.
May I
thank you.
Maraming salamat po sa inyo lahat.
May I ask one question?
Another round or just one? Okay.
Justice, you say you are the chairman of the Jail Congestion Committee.
Jail decongestion.
What is the truth of the report that the jail in Camp Karingal is so congested that prisoners do not sleep lying down; they sleep standing.
Well, you cannot sleep standing up, but it's really congested. In Manila, the capacity is 1,000. They have 4,000. I think Valenzuela and some other places, it's really even worse. I've not seen the other places yet, but I've been to Pasay. I went to jail, spoke to the prisoners, and your heart will go out for them.
What has been done about it?
Well, what we are doing is we plan to half the population of the jails, to reduce it to one half in 2 years' time. Because, there are a lot of them there who are there because they cannot post bond. As I said, our bail system is anti-poor. They could not post bond, but they are held only for property crimes. Well, we should keep allow them recognitions, and then keep only in jail those who are in the violent offenses or recidivists or things like that. But the others the first offenders that you take from their families, it's really a pity. The children, we make criminals of the children when you deprive them of their parents because they have no way of making money. You worsen the problem. Thank you.
Okay.
Ano?
Tama na, Justice Robert. Baka may magtanong ba?
Salamat sa inyo lahat.
Okay.
Thank you, Justice.
Your Honors, the next to be interviewed is Attorney Rafael A. Morales, partner Sisip Salazar Hernandez and Gatmaitan.
Oh, kaya pala.
Oh. Biglang nawala. Ha?
Wala tao.
Okay, Attorney Cayosa, please.
Thank you, Mr. Chairman. Good morning, Attorney Morales. What, to your appreciation, is the awesome responsibility of the Chief Justice?
The Chief Justice does not merely write decisions. The Chief Justice is actually the administrator of the Supreme Court. And I understand that 30% of his time is devoted to writing decisions, but the bulk of his time, about 70%, is devoted to administering the court system. And therefore, the Chief Justice must exhibit managerial skills because he will have to interact with the members of the lower courts, and also he will have to interact with the two other branches of government. I understand that there is a judicial, executive, legislative, advisory, and consultative council wherein the three heads of government sit down to thresh out problems of benefiting the country. And that is one of the functions of the Chief Justice. And I think he will have to make adjustment so that he will be able to fulfill those two-pronged functions.
Thank you, Attorney Morales. Now, let's tackle the adjudicatory function. Now, having worked in the private sector practically all of your legal career, throughout your legal career, how will you overcome the fact that you perhaps may have to undergo some kind of orientation as how decisions are prepared in the Supreme Court?
Well, the duties that I do in the private sector as the managing partner of Sisip Salazar Hernandez and Gatmaitan are almost similar to what a Chief Justice does. For the past 37 years, I have been writing opinions to clients, which is actually similar to decisions being written by the justices of the Supreme Court. Facts are presented to me by clients, and I render an opinion based on the facts and the applicable law. Also, as I mentioned already, the Chief Justice is the administrator of the entire judiciary, and I, as the managing partner, administers the different departments of my firm, and I interact with other colleagues. We are a member of 7 international networks, and I interact with them. So the functions of the Chief Justice are not really strange to me.
Which brings me to the next aspect of the question, which is on administration. And you mentioned that from what you know, 70% of the work that is to be done by the Chief Justice involves administration, particularly the administration of justice. What in your recent past will show that you have the skills required to manage and to administer justice?
In terms of management, I have been the president of the Inter-Pacific Bar Association, which is an association of more than 2,000 lawyers coming from more than 70 jurisdictions. And I was able to competently interact with the members. I presided over meetings with the General Assembly, and I think those are substantially similar to what the Chief Justice will be doing.
So what was something that you feel that was a major accomplishment insofar as, getting things done in the organization, which you feel is necessary for someone who has to manage courts nationwide?
Well, we held an international conference in Manila, and it was organized by myself as the chair of the host committee. And the theme of the conference was about the changing face of legal practice and how the lawyers could help in the promotion of social justice and generally cope with the changing face of the legal profession.
As a candidate for the position of Chief Justice, what is your vision for the courts? What do you want to accomplish in the judicial system within the next 5 years if appointed Chief Justice?
I understand that there is an action program for judicial reform in place, and that has been declared by the World Bank as the model for the region. During my watch as Chief Justice, I would like the entire action reform to be implemented, particularly in the matter of decongesting the dockets of the court and providing upward salary adjustments to judges so that the independence of the judiciary will be further enhanced.
I also noticed that you are the managing partner of CCIP Salazar Hernandez and Gatmaitan Law Firm, and how long have you had this? Have you held this position?
About over 2 years now.
And as managing partner, do you still actually litigate cases? Do you go to court?
I don't go to trial, but as managing partner, I am involved in litigation in the sense that I help conceptualize and strategize cases. My role as a litigator is akin to the role of a solicitor in the United Kingdom. The solicitor helps in strategizing the cases, helps in writing pleadings, but it is the barrister that appears before the court. And both the solicitors and the barristers are intimately involved in the litigation. My function is akin to that of a solicitor.
What to you is the most serious problem that is plaguing the judicial system today?
It is the inability of the courts to render judgment to dispose of cases speedily.
And what do you think is the cause of that delay?
It is because the courts are undermanned. If you have a vineyard in which there are a lot of grapes to be harvested and there are only a few workers, the logical step is to hire more workers. But in the judiciary, about 25% of vacancies has not been filled up. So the judiciary is undermanned. And that's why I was proposing the upward adjustment of the salary scales of the judges so that we can attract more applicants from a wider range of applicants. Yeah.
On a practical sense, when was the last time that you visited a court?
It was about a few years ago.
A few years ago. And which court is this?
Regional trial court.
Is it here in Metro Manila?
Yes, it is in Manila.
Okay, so you have not had the occasion to visit a court in the provinces?
No, but no.
How about, have you had any conversation with perhaps a judge or a court personnel to really find out, from their perspective, what seems to be the problem causing the delay?
Yes. And I've also been in discussion with my partners who are in the litigation department of my firm.
Okay. So what was your basis for coming up with these proposals, considering that it has been some time since you've actually been in the courts?
It is precisely my discussions with my partners in the litigation department. We have a very big litigation department in CCIP Salazar Hernandez and Gatmaitan.
I went through the list that you presented in your personal data sheet of the seminars that you've attended, also in the symposia that you have participated in. And except for two, which you participated in 1982, King of Administrative Agencies, and as a participant and a speaker for the opportunities and challenges of managing a law firm in just last April. The rest were all on banking, commerce, and taxation. How will you remedy the fact that perhaps with respect to other aspects of the administration of justice when it comes to criminal cases and to civil cases, what have you done to augment perhaps the lack of focus on these aspects of administration in your career?
Well, to be a trial lawyer is not necessarily a guarantee that you'll make a good justice. In fact, there are lawyers from our firm who became justices of the Supreme Court. And I could cite Justice Florentino Pipi Luciano, who was a corporate lawyer in my mold, and he became a good justice of the Supreme Court. Justice Sereno was a former associate of our firm, and she was not a trial lawyer. The acting Chief Justice was a corporate lawyer before he became a justice of the Supreme Court.
Well, I guess perhaps the challenge is becoming the next Chief Justice because there is so much that is expected of him, and therefore, if he does not have the skills required for the work, then perhaps we may still face the same problems plaguing our courts today. Now,
I have already mentioned, ma'am, that what I do in CISIP Salazar is similar to what the Chief Justice does. And I've reached the point in my career that I am willing, ready, and able to do full-time public service.
Thank you. You are in your 60s.
I'm 61
Yes.
years old.
Did it ever occur to you in the past to render public service?
Yes, in fact, every Saturday I teach at the College of Law of the UP.
Could you tell us what subjects you teach?
It's banking and finance, and then I taught for some time corporation law, legal ethics.
There is a constant clamor for our justice system to address the needs of the underprivileged. What reforms would you propose in order to meet this demand?
I am in favor of making the courts more accessible to litigants. I think that the filing fees are quite very high, and I'm in favor of reducing the filing fees. But in order to recoup losses possible from the reduction of legal fees, I would work for the increase in the share of the judiciary in the national budget. I understand that it is only 1%, and I'm surprised why that is too low. For a third branch of the government to be given only 1% of the national budget is, I think, scandalous.
In the choice of perhaps your legal team in the Office of the Chief Justice, what would be the qualities that you would look for in law clerks?
I would nurture and sustain integrity and excellence. I think those two qualities would serve our justice system very well. And by the way, those are the values, the core values. They are the cornerstone of CISIP Salazar Hernandez and Gemaitan.
My final question, Attorney Morales.
Yes, ma'am.
Why do you want to become the Chief Justice?
I'm not saying that the incumbent justices of the Supreme Court are not competent. However, we have reached a point in our history that an outsider should be given the opportunity to provide fresh and impartial approach to the judicial process. We have seen that the impeachment proceedings have eroded the dignity and credibility of the Supreme Court. It is time to restore that credibility, and the first step that should be taken by the President is to appoint an outsider as Chief Justice of the Supreme Court. I bring with me 37 years of legal practice from the largest and the leading law firm in the Philippines. I also bring the perspective of an academic, having taught at the College of Law for almost 15 years. And I also bring along with me the managerial skills that I have experience as managing partner of CC Salazar and as former president of the Inter-Pacific Bar Association.
Thank you, Attorney Morales. Thank you, Mr. Chairman.
Attorney Mejia.
Thank you, Justice Peralta. Good morning po,
Good morning.
Attorney Morales. I could see from your personal data sheet that you've been exposed to practice of law in foreign jurisdictions. No? What best practices have you learned or observed that you think you could introduce to our judicial system?
It is the ability to respond to clients in 24 hours. The promptitude with which one should take care of legal matters, which is not strictly observed in our court system.
We've been hearing about judicial reforms since we started yesterday. What to you is the real objective of judicial reforms?
I think the real objective is to provide justice, speedy justice to the people.
I also saw from your trainings and your area of expertise that you lecture and you do taxation work.
Partly, yes.
Maybe I'll take advantage of this opportunity to ask you, what is your assessment of our taxation system? We learned from law school that one of the characteristics of an ideal taxation system is that there must be theoretical justice. Is our present system in keeping with that yardstick?
I think that we should adopt the standard deduction so that you limit the discretion of the examiners when they examine or make assessment of taxpayers.
So you're suggesting that we revert, for example, to the system of gross income taxation?
Yes, something like that.
As my final question po, should you be appointed as Chief Justice, can you give us an idea of your work ethic as such Chief Justice?
I do work very diligently for the past 37 years. It is precisely the excellence which is a cornerstone in our law firm that over the 37 years of legal practice has propelled me to what I am now in my law firm. You know. It's diligence, promptitude, and reasoned legal opinions.
Thank you, Attorney Morales. Thank you, Justice Peralta. That will be all. Good luck po.
Justice Lagman, please.
Thank you very much, Mr. Chair. Attorney Morales, good morning.
Good morning.
You stated earlier that if you will be the next Chief Justice, you will provide real justice to our people. Can you please explain what you mean by real justice?
Well, it is whenever there is a case pending, it is the duty of a judge to dispose of it speedily.
Yes.
As the saying goes, justice delayed is justice denied.
Yes.
That way, people would have, redress of grievances. And I think speedy disposition of cases is a must so that the people's confidence in the justice system will be restored.
So, and if you will be the next Chief Justice, how are you going to do that? To speed up the disposition of cases or to declog the dockets of the courts nationwide?
Well, first of all, I would see to it that the vacancies would be filled. Secondly, I think that we have to strengthen the research staff. We should employ more researchers, and if possible, we employ interns.
Interns?
Yes, so that there will be additional bodies that will do research and speed up the work. And I think we should encourage shorter decisions. For instance, if the Supreme Court thinks that the decision which is under appeal from the Court of Appeals is sound, then the Supreme Court's decision should merely say that we adopt by reference the facts and the findings of law of the Court of Appeals, and then, you know, a one-page decision would be all right, and in compliance substantially with the Constitution of the Philippines.
Okay. Attorney Morales, considering your experience, there's no doubt that you possess the management skills required in running the judiciary. However, to effectively discharge your function as the Chief Executive Officer of the judiciary and lead the court, you must do it with moral ascendancy. And you can only have moral ascendancy if you have the respect, the trust, and confidence of all the associate justices working with you. Attorney Morales, can you tell us how you intend to get the respect, the trust, and confidence of the incumbent justices, most of whom are older than you, not only in age, but in terms of length of service in the judiciary?
I am a consensus builder.
Yes.
I would like to reach out with my colleagues at the Supreme Court and appeal to their sense of patriotism, seek their cooperation in the interest of country and people. And with respect to seniority, I think that seniority is not always observed in the Supreme Court,
Yes.
as borne out by the fact that two younger justices are candidates for the position. And also, the acting chief has come up with a declaration in an interview that he would respect the decision of the President of the Philippines, whether the appointee would be an insider or outsider.
Okay. So, during the impeachment trial of the former Chief Justice, the moral fitness of a candidate for that position was raised. Now, can you tell us your perception of moral fitness as a criteria in selecting the next Chief Justice?
Moral fitness is number one in my list. Honesty is the best policy. You know? Without integrity, on the part of the Chief Justice, people would not repose trust and confidence in the court system.
Okay, let's go to another point. It is given that the two political branches of government, namely the executive and the legislative, have the primary responsibility of promoting the economic well-being of the country. In one of his lectures, a former Chief Justice stated that the judiciary has a similar duty to nurture prosperity and alleviate poverty in our country. Do you agree, Attorney Morales?
To some extent, although on matters dealing with the economics,
Yes.
I would probably exhibit judicial restraint.
How are you going to do that? How are you going to do that?
If a case is brought before the Supreme Court and it concerns economic policies, then I would probably exhibit judicial restraint in that I would uphold and sustain the policies promulgated by the executive or the legislative branch.
Okay, I'm sure you're aware of that provision in the new constitution that it is not only the power but the duty of the court to strike down acts of any branch or instrumentality of government committed in grave abuse of discretion.
Yes, ma'am.
So, do you want to comment on that in relation to your previous answer?
Well, that actually expanded judicial review,
Yes.
and that eroded somewhat the political question doctrine, and that answers the criticism founded on the doctrine of counter-majoritarian, because whenever the Supreme Court strikes down as unlawful or unconstitutional a legislative or executive act, the Supreme Court is said to be counter-majoritarian, because those acts are acts of the political branches of government that have been elected by the majority of the people. But again, that loses sight of the fact that the Supreme Court is granted by the people under the Constitution to determine whether there has been a grave abuse of discretion amounting to lack or excessive jurisdiction by any instrumentality of government.
Yes. Okay. Now, if you will be fortunate to be nominated and appointed as the next Chief Justice of our country, will you kindly tell us your top 3 priorities upon assumption of office?
I'm going to fill up the vacancies because judiciary is undermanned. Second, I would work for the upward adjustment of salaries to prevent or to stem the brain drain in the judiciary, because we cannot attract the bright people because the salaries in the private sector are very high compared to that in the judiciary. Then I would work for the increase in the budgetary allocation of the judiciary.
Okay, Attorney Morales, this will be my last question in connection with your answer. We all know that a Chief Justice is both a jurist and the Chief Executive Officer of the judiciary. As a jurist, a Chief Justice is expected not only to be actually independent, but must be perceived as independent at all times. However, as a CEO, he has to deal with officials from the other 2 branches of government and maintain a harmonious relationship with these people. Now, can you tell us, Attorney Morales, how you can balance these 2 seemingly conflicting functions? How can you preserve your independence and at the same time maintain a cordial relationship with the officials of the other 2 branches of government?
The 2 justices are not mutually inconsistent. Independence, a judge is independent if he's able to decide the case purely on the basis of the merits,
Yes.
and swayed by any partisan interests, not influenced by family, social, or other relationship. That is independence as defined in the Code of Judicial Conduct.
Then,
Interacting with the executive or legislative officials does not necessarily detract from the independence of the Chief Justice. In fact, that is supposed to be encouraged, because the judiciary is not supposed to be staying in the ivory tower.
so your idea is of a Chief Justice is not to stay in the ivory tower all the time, but he has to go out.
Yes, ma'am. Precisely, the Judicial, Executive, Legislative, Advisory, Consultative Council was created
Gila.
precisely for that purpose, for the interaction between and among the heads of the different branches of government.
So you believe in the benefits derived from activating this GLAC?
Absolutely.
Okay. On that note, Mr. Chair, I have no more questions for Attorney Morales. Thank you, Attorney Morales.
Justice Hermosissima.
Good morning, Attorney Morales.
Good morning.
Any relation to the Ombudsman?
No relation.
No, no relation at all. I was hoping you'd say yes. Well, the tremendous inherent power in the hands of the Chief Justice of the Supreme Court require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence. Because the administration of justice is a sacred task, entrusted only to individuals with the highest degree of competence. A judicial position is a position of honor and is offered only to those who are best qualified. You have never been a judge before, nor were you a justice of the appellate courts. How do you assess yourself in connection with these ideals?
Well, I have the requisite competence, integrity, probity, and independence. As I said earlier, the cornerstones of the practice in my firm is integrity and excellence, and we have been doing that since the time the CCP law was founded in 1945. We are an apolitical firm, and we do not subscribe to political connections in the pursuit of our legal profession. And I'll be bringing with me no baggages with me, no strings attached when I become, if ever, the Chief Justice of the Supreme Court.
Well, your senior partner, Justice Feliciano, was together with me in the Supreme Court. And I can say without any opposition that he is the paragon of a good justice. And so if you are a member of his firm, then the possibility is that you are also of the same mold.
He is precisely my model, Mr. Justice.
What is your judicial philosophy? If you become a Chief Justice of the Supreme Court?
Mr. Justice, a judge's judicial philosophy or decision-making process is largely shaped by the Code of Judicial Conduct. Canon 3 of the Code states that a judge must determine the facts and apply the applicable law to the set of facts. So if there are clear-cut legal norms applicable, I would simply apply the legal norms to the set of facts. However, there are situations where there are no clear-cut legal provisions or norms that are applicable. But I have to decide the case because the instruction in Article 9 of the Civil Code is that no judge shall declined to render judgment because of the silence, obscurity, or insufficiency of the laws. But in those cases, I have to navigate uncharted waters using my experience as a guide and guided by my beliefs. So there's a spectrum, one end of which is judicial activism and the other is judicial restraint. I will be inclined to be an activist if a person is unreasonably deprived of his life or liberty or even property, or if there has been a grave abuse of discretion on the part of a particular branch of government. So for instance, if I may illustrate, if I were a justice of the Supreme Court at the time the case of Allied Banking Corporation versus Court of Appeals was decided, I would have dissented because in that case, the majority expanded the coverage of the trustees law in violation of the fundamental tenet that penal laws must be strictly construed in favor of the accused and its scope should not be expanded by implication. On the other hand, if I were a part of the Supreme Court at the time the case of Salvacion versus Central Bank of the Philippines was decided, I would have sided with the majority because there the Supreme Court prevented a foreign national who had raped a 12-year-old Filipina from using as a defense the provision in the Foreign Currency Deposit Act prohibiting the garnishment of his deposit. If the Supreme Court did not allow the garnishment of the deposit of that foreign national, justice would have been compounded. Justice would not have been served to that rape victim. But then, to summarize, if
I'll give you an example.
Oh,
when,
right.
when you enter the portals of the Supreme Court of the United States, you will see emblazoned the following words: equality under law. It's a revelation of the court's judicial philosophy. Here in the Philippines, the Supreme Court of the Philippines, what do you have? Batas Bayan. That's their short term. Now, the integrated bar of the Philippines has this: no master but law, no guide but conscience, no aim but justice. In your case, how do you shorten your judicial philosophy?
I think those mottos are just a short restatement of the concept of independence, that the judge must dispose of a case purely on the basis of merits in accordance with justice and law, without being influenced by any extraneous factor.
Do you abide by the judicial philosophy of the integrated bar of the Philippines? No master but law, no guide but conscience, no aim but justice.
Yes, justice, yeah.
Why? What is your concept of justice?
Justice is being able to provide speedy disposition of cases, because justice delayed is justice denied.
So, on what basis do magistrates base their opinions, their decisions? On the basis of law.
In the basis of law, yes.
So, if the law does not coincide with your conscience, will you abide by the law?
I think, unless amended, the applicable legal norms should be applied, Mr. Justice.
If the law does not coincide with your concept of justice, will you abide by the law?
It depends on the factual circumstances at the time. I am between judicial activism and judicial restraint.
What subject in law is your forte, Attorney Morales?
When I was a law student, I excelled in all subjects, Mr. Justice.
Yes, you made it with the grade of, you made the bar in the grade of 87.79. Was that?
I was number
did you
4
have
in the bar
number
exams.
4? That was number 4.
Yes.
So what was your highest grade in the bar?
It was political law, I got 97, criminal law 96.
You will realize, but in your practice now, you also delve in corporation law.
Yes.
Well, that's in your law office. You accept all kinds of cases.
We are a one-stop firm. We cater to all the needs of our clientele.
That's good because the Supreme Court is a court of general jurisdiction, and so you have to be an expert in all kinds of law. Although that is impossible, really.
Yes, I'm actually a specialist and a generalist at the same time.
So, deep inside you, you believe that you are deserving of appointment to as Chief Justice of the Supreme Court.
Yes, sir.
On that note, thank you very much.
Congressman Tupas.
Thank you, Mr. Chairman. Good noon, Attorney Morales. Yeah. You're the managing partner of CSIP Salazar.
Yes,
Law
sir.
Firm.
Yeah.
Okay. And it seems that at least sa akin, no, sa pananaw ko, at least parang you have this lucrative practice, di ba?
Yes.
As dun sa one of the leading major law firms. Ano po yung naisip nyo? Bakit gusto nyo pang pumunta sa gobyerno at sa third branch, yung one of the 3 branches of government na dito mahirap po sa gobyerno, di ba? May SALN po dito, may pahiling ng SALN, may waiver pa. No? So gusto ko lang malaman yung dahilan, yung main reason bakit po gusto nyo, let's say, give up itong practice nyo tapos punta kayo dito sa gobyerno bilang aplikante sa posisyon ng Chief Justice?
I have reached a point in my career that I'm already willing, ready, and able to render full-time public service. I think I have more than sufficient savings, and I want to give back something to my country.
Before this, nanilbihan ba kayo sa gobyerno?
Nagturo po ako ng
Turo?
almost 15 years sa UP.
Yung law firm, di ba? Like tayo, ako, nag-practice rin ako sa, naging associate rin ako sa isang law firm. At mukhang iba ata yung pag-manage ng law firm kaysa pag-manage the entire judiciary. 'Diba na buong sistema. So paano nyo yung skills nyo, let's say as a managing partner now, makakatulong ba 'yon? Sapat ba 'yon para maging Chief Justice ng Korte Suprema?
Definitely, sir. If I become a Chief Justice, I intend to visit the different salas in the different provinces, see what their needs are, and see whether we can provide a separate buildings for as courthouses in those provinces, because it doesn't appear good that courtrooms are inside the city hall. They should be separated from the city hall.
Kanina, meron kayong statement kanina, no? Sinabi nyo na the impeachment has eroded the integrity of the Supreme Court and the judiciary. Diba? So, parang I was taken aback because ang opening statement ko noon is yung impeachment, nangyari yon to bring back the dignity, integrity, and honor to the Supreme Court and the institution. So, pwedeng paka-explain lang nun. Bakit yung process ba, in-erode niya yung integrity and credibility?
Yeah, you're
ano
right.
ibig niyo sabihin nun?
You're right in the sense that it has restored credibility because the constitutional process have been served. We were able to remove a Chief Justice that was perceived to be guilty of some offenses. But what I am driving at, because I was asked a question of whether or not why would be something like, why would an outsider be the Chief Justice? So I answered in that context.
So personally, okay sa inyo yung nangyari?
Of course.
Okay,
Yes.
personally.
Personally, yes.
Meron din dito katanungan lang from the Twitter nung JBC siguro. Tanong natin yung just few questions. Ano raw yung comment nyo dito sa practice na yung mga law firms through retired justices sumusulat sa Korte Suprema? What's your comment on that?
Well, I would not countenance that practice.
Okay, so ayaw nyo yun. Ayaw nyo.
Ayaw.
Meron ditong katanungan rin na, are you aware raw or alam nyo na yung law firm ninyo, ito binabasa ko lang po sa Twitter ito, na through sa isang retired justice, sumulat rin po ng personal letter sa Supreme Court. Totoo po yan? Nangyari ba yan? Yung sa law firm, through parang off-counsel?
I had no personal knowledge of that, but I have read that in the papers.
So no personal, pero ayaw nyo yon, hindi nyo ito tolerate yon.
No.
Okay. Siguro, last question na lang, Mr. Chairman. Yung isang kaibigan ko dito sa media, si Karen Davila, meron tweet dito. Yung mga budget cuts, di ba, lalo na yung last budget nung last year, parang nagkaroon ng controversy yung executive, legislative, at saka yung judikatura sa mga budget cuts na nangyari. Cut supposedly by the executive proposal. So, sa inyo ba, anong pananaw nyo dito sa pondo ng Korte Suprema?
Share in the budget? Or?
Yes, the share of the budget, budget cuts. Ito yung mga issue na to na parang nagkaroon pa ito ng mga rally or protest sa mga korte all over the country.
To the extent possible, I would resist any budget cut on the judiciary's share of the allocation in the budget.
Resist budget cut or increase?
Well, resist the budget cut and therefore increase it, yes.
Okay. Thank you, Attorney. Thank you, Mr. Chairman.
Secretary Mosgi.
Mr. Chairman, I think all my queries have been sufficiently addressed. I have no further questions for the aspirant.
Thank you.
Okay, now how would you address the problem of dockets of courts, especially the lower courts?
First, I think there should be strict enforcement of the deadlines. Second, I would increase the staff complement of the different salas so that there will be more bodies to do the research work and assist the judge in disposing the cases speedily.
But that solution might take years to happen because you will have to contend with the rules of the civil service. If you want to increase the personnel of an office in government, the Supreme Court has just increased the number of employees. You will have to contend with the rules of the civil service.
Then can we not hire?
You will have to go to Congress for additional budget.
Then
You will have to justify to the executive, to the Department of Justice, Department of Budget, that you need this amount.
Then I would liaise with the executive and the legislative branches in order to precisely to implement that proposal.
Anyway, that's a long-term solution. I am talking about short-term solutions in order to reduce the backlog of the cases in the lower courts.
And fill up the vacancies. And probably hire interns.
Higher?
If we could not immediately hire permanent clerks or researchers. But the thing is, we must fill up the vacancies because it's intolerable that the vacancies is at 25%.
What is your position in the adoption of rules to the effect that instead of an oral testimony of witnesses, the witnesses' testimony shall be in affidavit form, which we sometimes call judicial affidavits. Are you in favor of the use of judicial affidavits?
I am in favor of that use, provided that there's an ability to cross-examine the
Of course,
client.
there is. Of course, the other party will have to cross-examine, but there are some resistance, or there are resistances rather, because if you do that, especially in criminal cases, judges will not be able to determine the demeanor of the witness. And one way of determining the demeanor of a witness is the credibility of the witness is the demeanor of the witness when he takes the witness stand.
I think that the determination of the demeanor of the witness might come during the cross-examination.
Well, but if you allow a judicial affidavit, you can just imagine that if the judicial affidavit is prepared by the counsel, of course it will be the best judicial affidavit. It will be the best affidavit because practically the witness is already taught what to say. Unlike when the testimony of the witness is made orally, and I am referring to direct examination, where the case is developed through the questions and answers. And you can also, it's also needed, I mean, you can determine the demeanor of the witness, therefore, not only on cross-examination, but likewise on direct examination.
Yes, you are articulating the possible drawback of the proposal.
So that's why, no, it was a follow-up question because according to you, the demeanor of the witness may be determined through the cross-examination. But what I'm saying also is that you can also determine the demeanor of the witness on direct examination.
Of course.
So what is your position now? You are in favor of judicial affidavit?
Well, I thought that you were proposing it as a means to accelerate cases.
Yeah, no, I'm just asking if you're in favor of a judicial affidavit instead of a direct examination in order to expedite cases.
I'm inclined to favor to some extent. Yeah.
What about amendment of the rules of court? Are you proposing the amendment of the rules of court in order to expedite cases? Because I think if I heard you right, you were saying that you will be strict on the periods within which to terminate a case. Did I get you right?
Yes.
Yeah. But we have already periods under the rules.
It's a matter of implementing it strictly.
You want that it be strictly implemented?
Yeah.
No. Aside from the strict implementation of the periods provided for by the rules and other laws, what else do you suggest?
It's probably good to remove technical requirements
Technical, like what?
Like, for instance, if there are defects in the verification or in the
Oh, you're referring to initiatory pleadings, probably complaints.
yeah, well, then if
you're
there's a
referring-
defect in the verification or similar things, no, that judges should not be strict.
But if you know, just for your information, in the data submitted by, presented by Dean Bautista yesterday, the disposal rating of the Supreme Court is high. I think it's something like 60%. The disposal rating of the Court of Appeals, likewise, is possible, no? But the disposal rating of the Sandigan Bayan, the lower courts, is low. Probably the reason is that the Court of Appeals and the Supreme Court are not trier of facts. In other words, they are not trial courts.
All right.
We resolve cases based on the pleadings, no? Also in the Court of Appeals, they resolve cases based on the pleadings. But in the lower courts, before they could decide cases, they will have to hear the cases.
Yes.
Also in the Sandigan Bayan, because in Sandigan Bayan it's a unique court. It is an appellate court because the cases that are decided by the lower courts, insofar as commission of crimes by public official, go to the Sandigan Bayan on appeal. But they have also original jurisdiction. They hear cases. And the backlog of cases, I think, is attributable to the long process of presentation of evidence, which means trial. Do you agree? Tony, do you agree on that? In your practice of law, do you agree that there is really delay in the cases before trial courts? Do you agree?
That's right.
So aside from judicial affidavits and aside from strict adherence to the periods within which to resolve cases, what proposal?
Well, continuous trials.
Continuous trial. We have also that in the rules. Under the speedy trial, continuous trial.
But not strictly implemented.
What about the pretrial rule? Is the pretrial rule an effective measure of expediting the termination of cases?
Yes, of course.
Of course.
Yes.
Yeah. As a practitioner, have you appeared before judges, and have you observed them strictly following the provisions of the rules on pretrial?
Not in the recent past.
No. But even when you were a new lawyer, there was already a rule on pretrial.
Yes, that's right.
Yeah.
Yes.
Now, there is also a question from the Twitter. Oh, before I go to that, yeah, this comes from the Twitter, but because of that question, I'm reminded of that case, the one that you mentioned about Salvacion versus Central Bank.
All right.
That is a decision regarding the interpretation of the Foreign Currency Development, Deposit Act.
Yes.
Whether or not dollar deposit can be opened, considering the fact that there is an absolute confidentiality, and it can only be opened through the consent of the depositor.
Yes.
Is that right?
Yes.
Yeah.
But
But in Salvacion, according to you, the court required the opening of the foreign deposit.
it's the garnishment.
The garnishment,
Yes.
yeah, it allowed the garnishment
Yes.
because of that civil liability awarded by the court in a rape case.
Yes.
Because you could not probably anymore, because there was no way to enforce the damages awarded by the court, if not through this deposit.
Yes. Yes.
But you agree with me that that case is merely pro hac vice,
Yes, it's pro hac vice.
only for that case.
Only for that.
Only for that case.
That's right.
Not in other cases, no?
Not in other cases.
Now, there is another question here, no? Should retired Supreme Court justices accept directorships in corporations who were involved in cases they previously decided?
I would not do that personally. You know.
What do you mean you do not do that?
I would refrain from accepting directorship after my retirement.
Yeah, because under the law, I remember under 6713, you're not supposed to accept positions positions in institutions where those institutions had cases before the court within a period of 1 year. I think that's the provision.
That's right. But even after 1 year,
under Republic Act 6713, it is indeed prohibited within the 1 year period. Okay. Beyond that 1 year period, if you were now a retired as a justice, would you accept?
I would not accept.
Definitely.
Definitely, I would just go to teaching.
You will
Go back to teaching.
You will be content with a pension, probably of a small amount.
Yes, but I have
From the
more
Supreme
than
Court?
savings from my law practice, so money is not an issue.
So because you already earn a lot you already earn a lot in the practice of law, there is no need to go back.
Yes, sir.
Yeah. Okay. Not even your law office, you will not go back as an off counsel.
No.
No more.
No more.
Now, my last question is, because of your background, Attorney Morales, you've been representing probably big businesses, no, paying high fees, and private individuals paying high fees, no. In other words, your practice is quite lucrative, no.
Yes, sir.
You're lucrative. And you now become the Chief Justice. Now, I'm just wondering, how would you lead and deal with 14, because you're coming from the outside, 14 experienced justices. Because if I use the word learned, my question might be biased because I'm included, no? So let's assume that experienced 14 justices, and you're coming from the outside.
I would, as I said earlier, I would approach each and every justice and appeal to their sense of patriotism, appeal to them to extend their cooperation to me in the interest of country and the judicial system.
Okay, last question. What is your edge over incumbent justices?
I bring fresh and impartial approach to the judicial process.
So those incumbent justices are no longer fresh.
I'm not saying that.
Okay. On that note, I'm through. Thank you, Attorney Morales.
Your Honors, the next to be interviewed is Professor Raul C. Pangalangan of the University of the Philippines and Chairman, Bantay Katarungan.
You may take your seat, Dean. Now, upon request of Congressman Tupas, he will be the first to ask the questions. So, Congressman Tupas, please. Anyway, you already submitted your written opening statement. It's already 12 o'clock.
Oh yes, of course.
Another hour.
Something
Dean, first of all, you are 53 years old now. Is that correct?
That is correct, Your Honor.
quite young dun sa standard ng mga aplikante, di ba? And if appointed Chief Justice of the Supreme Court, you will serve 17 years.
That is correct,
Diba?
Your Honor.
Kanina, when we were interviewing yung first na interview dun sa incumbent justice, si Justice Abad, parang very, very clear rin yung stand niya dito eh. At least sa akin. Sinabi niyang, dapa na nga eh. Diba sinabi niya, dapa na ang Korte Suprema after impeachment, tapos lalagyan pa ng outsider, lalong dapa. Dagan. Meaning, yung, at least yun sa isa sa mga insiders or incumbent, na siyempre prefer nila yung insider. For many reasons probably. And probably yung, isa sa reason doon yung age, isa doon yung experience. So, paano mo pupunuan ito, Dean, if ever, na ikaw yung ma-appoint, or ma-nominate namin muna at ma-appoint, how would you address yung problems na to? Na, outsider, ito experience yung mga kasama mo doon, matatapakan mo, or hindi naman masasapawan mo yung iba, hindi na magiging Chief Justice. Diba? So, how would you address these problems?
Yes. Thank you, Your Honor, for the question. First of all, hindi ho ako bago sa sitwasyon na yon. I became dean at the age of 40. My predecessor was then retiring at the age of 65. He belonged to class 58 of the UP College of Law. I was born in 1958. So the gap was rather big. It did not pose any problem to me. My successor also was actually eventually retired in office. So if the question is whether being young comparatively is a disadvantage, it can actually be turned into an advantage. So, for instance, I enjoyed wonderfully the support of my most senior colleagues in the faculty, and they helped me throughout my deanship. I had 2 terms as dean of the law school, and that is why, for me, when I look at the issue, for instance, of what people now call a divided court, a court with well-identified camps. That is a situation I have faced before, of presiding over highly articulate, very intelligent, assertive faculty members who have different opinions, and getting them to work together under my leadership and achieving the goals that I have set out for the institution.
Doon naman po sa, di ba yung Article 8, Section 1, yung expanded jurisdiction. Gusto ko lang, very briefly lang, Dean. Ano ang pananaw mo doon sa expanded jurisdiction of the Supreme question?
Yes. Thank
Just
you.
very, very, very briefly lang.
Opo. Your Honor, we must look at that provision in the context of history. Why did we write paragraph 2 to the expanded definition of judicial power? It was based on our experience under martial law, that the activists at that time turned to the courts for sanctuary, for refuge, and invoked the rule of law. And that is why, with the triumph of EDSA I, Cory appointed constitutional commissioners who wrote that entire approach, that entire philosophy into the 87 Constitution. So when we now arrive at this situation of what they call the expanded, expansive exercise of judicial review, of judicial activism, it is not that we are pointing fingers and accusing people. It is that we are seeing the inexorable march of history, which brought us to that moment. But, Your Honor, it is now 25 years since the 1987 Constitution. A quarter of a century since EDSA I, the foundational moment of the post-Marcos constitutional order. That is long enough for us to look at whether this judicial aggrandizement has served the country. And I think the lesson is it has not. And that is why I respectfully submit that I think the time has come to review that, to reinterpret that clause without necessitating any constitutional amendment. All we need are tried and tested judicial doctrine. The case and a controversy requirement, the rule on standing, political question doctrine, the rule of primary jurisdiction. Lahat po yan available sa husgado if it wants to define its place within our democratic system.
Ang ibig nyo sabihin na during those times, parang dun sa delineation na yon na because of that expanded jurisdiction, sumobra ang korte doon. Parang naging activist siya. Yun ba yun? Yes or no? Siguro lang ang answer dito.
Yes, sir.
Yes.
And there are
Can
two
you cite
examples.
one case?
Well, sir, the cases that are quite famous. Luzon Petrochemical, Garcia versus Board of Investments, and then of course there's the Manila Prince Hotel case. These are the notorious cases. Along.
Okay. Yung political, yung maliwanag na political question. Meron?
Well, Your Honor, I defy politics in terms of the way the court would push a certain decision toward a desired conclusion. In other words, I call it the manipulation of text.
On the issue naman of yung JDF, di ba? Judiciary Development Fund, at saka yung SAD, Special Allowances for Judges. Matagal-tagal na rin itong mga issues na to, no? Pag ikaw yung, let's say, from the outside, appointed Chief Justice, anong mo-offer mo dito na improve yung system of, let's say, transparency? Ibig sabihin, paano mo nakikita ito bilang minamanage ngayon ng Korte Suprema? Itong JDF and SADS. And meron bang pagbabago pag ikaw ay naging Chief Justice?
Well, Your Honor, again, if you look at it in terms of the developments over the years, the JDF, the power to dispose of the JDF was well, actually, strictly speaking, reposed on the Chief Justice. It is just over time that it was expanded to include the collegial participation of the rest of the court. That is where we stand today. And I think that that is a good development which I propose to sustain, and also to sustain the goal of transparency. Because this is a fund that, because of the fiscal autonomy of the court, is beyond reach of the other branches.
Is it being managed well right now, to your opinion? Based on your opinion, is it being managed well?
Well, Your Honor, just based on informal information from conversations with members of the judiciary, I feel that there is a sense that the fund can be managed in such a way that there will be more benefits to
do you know
the
how
lower
much?
ranking.
Do you know how much is this?
No, Your Honor, I'm not.
You don't know.
I'm
So
not
hindi mo alam na billions ito.
I am aware
You know,
that it is that
billions.
big, yes, Your Honor. Well, it was, in fact, the bone of contention in the impeachment of Chief Justice David, and I was amicus counsel in that case. I was designated by the court as amicus counsel.
Okay. Okay, Dean, so doon tayo sa... Dati kasi, di ba, matagal na kayong hinihirang as nominee. Di ba? Ilang beses na ata, even before pa ako na-appoint dito or na-designate ng Kamara.
Apo.
Tapos sabi, si Dean Raul Pangalangan, palagi yan eh. Pero hindi na-appoint yan. Diba? Kahit dito sa kahit Justice, Associate Justice.
Apo.
So, tingin mo may pagbabago ba ngayon na Dean, na let's say, pag nakonbinsi mo kami dito at isa ka sa Lunes, no, July 30, Lunes ng umaga, na isa ka dun sa 3 to 5, for example, 3 to 5 na nominees ng JBC. Tingin mo may pagbabago ngayon na hindi na perennial na hanggang nominee na lang?
Shortlisted
but not appointed.
Yes.
Tingin mo, realistically,
well, Your Honor, the most dramatic difference is the events that brought us here, namely the impeachment of a sitting Chief Justice. Never before happened in Philippine history. And also, my first nominations happened under President Arroyo at that time, a long time ago, I think 10 years ago. And so I think conditions have changed, Your Honor.
So may pag-asa ngayon, tingin mo?
Well, one can hope springs eternal, Your Honor. But in fact, Your Honor, just to show you the effect of the impeachment trial, had it not been for that event, no outsider will even be sitting before the Judicial and Bar Council to be considered for this office. No outsider will even have the nerve to accept a nomination if he is nominated, because it's just too much of a burden, of an overwhelming barrier. But because of those events, here we are.
Last question, Your Honor. Ito sa academe kasi, di ba, yung merong perception. Like kayo po, di ba, academe talaga kayo. At parang sinasabi nila sometimes, pag sobra na doon sa field na yon, parang giging out of touch of reality na tayo. Di ba? Na tayo sa realidad. At pag Chief Justice ka ng Korte Suprema, definitely, dapat talagang alam mo yung reality. Di ba? Yung the congestion of
The dockets, yes.
Di lang dockets eh. Yung doon lang yung jail. Lahat yan talagang bababa ka eh. Personal experience lahat yan. So, yung paghahanda ba din, paghahanda mo sa sarili mo with all these years doon ka sa academe, tingin mo magiging sapat ito. Coming na yung Chief Justice, hindi biro ito. Hindi ito madali, hindi ito parang ideas lang lahat, di ba? Hindi siya ideas, hindi siya concept, di ba? Not just the vision, even if you have the vision, baka hanggang vision lang, but you should implement that. You should make things happen. Kailangan natin ng action dito sa susunod na Chief Justice. Do you think po, do you have it?
I respectfully submit, yes, Your Honor. Because fortunately or unfortunately for me, as a Filipino law professor, I still have to involve myself in the practical problems of day-to-day life. So on 2 points, Your Honor, in terms of practical experience in the law, I was in fact the University General Counsel for a while, and in that capacity I had to handle the loftiest issues on academic freedom before the Supreme Court, to the nitty-gritty of the contracts with security guards, to the discussions with labor unions. So in terms of getting involved in the practical problems of that lawyers face, I have faced them. I am chairman of the Bantay Katarungan. We continue to handle cases before the courts, some of them before the Supreme Court. But, Your Honor, on the second point, well, on the point of administration, of actually running an organization, well, Your Honor, I had 2 terms as dean of a public law school, which means that I'm familiar with all the difficulties of dealing with government procedure and of the bureaucracy, and of the need basically to supervise a whole range of an alphabet soup of committees and organizations, and divide by time and attention among them.
That's all, Mr. Chairman. Thank you, Dean.
Well, thank you, Congressman.
Attorney Cayusa, please.
Thank you, Mr. Chairman. Good afternoon, Dean.
Good afternoon.
In your presentation at the IBP Forum, you propose the depolitization or the depoliticizing of the courts and a managerial approach for judicial reform. Now, before I ask you to expound on that, maybe you would like to identify what particular problems were you actually addressing by making these proposals?
Oh, okay. Your Honor, on the first part, you see, Your Honor, whenever we speak about the institutional autonomy of the judiciary, judicial independence, we think in terms of immunizing the appointments process from politics. And the chief mechanism, of course, is the Judicial and Bar Council. We think of fiscal autonomy, the budgetary power of the court, so that it can operate and work without constant intrusion from the political branches of government. And what I wanted to point out, Your Honor, in the IBP Forum, is that there is a completely separate and distinct source of political pressure on the court. And that is of the court being drawn into political controversy. And the best proof, Your Honor, is that today there is an official court spokesman. Inherited wisdom says that a court speaks only through its decisions and nothing beyond that. And that was the position, in fact, of the court. I still remember when it was first proposed. That was the official position of the court. Why will we hire someone to interpret our decisions for us? And yet today, it is an entrenched position. Why? Because our people have higher expectations of accountability. They want someone to announce a decision on mass media and explain it to them in popular terms. So, Your Honor, that is for me, the other angle of pressure upon the courts. And that is why, for me, faced with that pressure, the court is, as I've said earlier, under pressure to respond to some of the, let us face it, there will be rallies, there will be concerted campaigns in the newspapers for or against a certain decision, for or against a certain party. And we have to strengthen the court so that it can stand firm, stand fast against such pressures. That's where I was coming from, Your Honor.
Okay. I guess for some, or for many, especially the court employees, they're really more concerned, how will the next Chief Justice improve our quality of life, how we are able to perform our functions as court employees? Well, how would you address those concerns?
Your Honor, I can actually build upon my own record as an administrator at UP. I always push for improved. In fact, that is. Thank you, Your Honor, for your language. That is how I called it: the quality of life, the quality of life of our employees, and creative ways to improve their salaries and their benefits. So that is a cause to which I have long ago committed myself. I would like to think I delivered upon that hope vis-a-vis my own employees. And for the court, Congressman Tupas asked earlier about the JDF. There is also, of course, the budgetary allocation from the national government. It is my hope that those are the sources by which that can be tapped to
Could
ensure.
you be more specific as to how you would improve the quality of life? I mean,
Well,
of course, it helps if their income is augmented.
Yes.
But other than that, is there something else that you may want to propose that would improve the quality of how they live, so that they'll be encouraged also to improve their services?
Well, Your Honor, of course, enhancing salaries and benefits would be the key element, and that is accessible via the JDF. So for me, Your Honor, it is not an iffy prospect, as iffy, for instance, as saying that we must secure a greater budgetary allocation from the national government. Certainly, that is something that we should hope for. But I think within the JDF, that should be doable.
Thank you, Dean. Now, the courts are only as good as the people that you put in them. So that is a bigger responsibility of the JBC. But I read in your opening statement that you have some criticism as to how, the process by which we nominate judges, as well as the requirements. Now, first of all, let's go to the requirements, the documentary requirements. Which one did you find difficult to comply with?
Your Honor, I had to get, I think, 8 or 9 clearances from different government agencies. And if I put myself in the shoes of a young lawyer looking for an entry-level position in the judiciary, and he doesn't have access to staff, and he would have to drive from one office to another, we are basically taking back with one hand what we give with the other. In other words, we encourage him, we push him to apply, and then when we're about to apply, we make it so difficult. I propose, Your Honor, a very practical solution. These are doable through interagency agreements that the JBC can arrange with all the government agencies involved. Just to show you, Your Honor, the details and the nitty-gritty of this. I imagine they might resist it because there will be an income. There will be foregone income because right now there is a fee that is charged for these clearances. But again, it is my hope that is an element that the JBC can negotiate with these officers, so that when the when the applicant puts together his file before the JBC, he can focus on the substantive stuff the things that he has written, the things that he has done, rather than getting the purely ministerial clearances, which can be dealt with purely administratively without burdening the applicant. So that is my. I hope it wasn't seen as as an attack upon the institution. In fact, Your Honor, given a choice between the JBC system that we have today and the pre-martial law system under the 35 Constitution, I do go for the JBC system because I have. We have seen how that operated. That we borrowed the system from the U.S. I have read how it operated before under martial law. I have seen on TV how it operates before the U.S. Confirmation proceedings, and I think that the JBC system is the preferable system. So it's not a fundamental criticism. But yes, I did present those suggestions before the integrated bar. The other, Your Honor, is a more proactive sense of recruitment, of spotting good material out there. It is difficult to do it, certainly from the standpoint of the council working alone. But I think the council can also join hands with the integrated bar, with the local chapters, with retired judges. These are the people who have either the time or the energy to spot good material out there, to encourage them to apply. I've seen it happen, and I think that a more proactive recruitment of material, and Your Honor, starting not just with young lawyers, but trying to spot them even at the stage of law school, those with a judicial temperament, should have a good effect.
Thank you on your suggestions, well taken. But it may interest you to know that we've already started addressing the problem on the documentary requirements. For instance, you can actually just phone in your request to the IBP and then pay online. You need not go there personally to get a clearance. And insofar as the ombudsman clearance is concerned, you may actually apply for it online if you're not aware yet that's.
I'm not.
Okay, then we're on that track. But other than that, there's no other way for us to determine whether you have all the qualifications and none of the disqualifications. So, like I said, the point well taken. Now,
Your Honor.
on this will probably be my last question, considering the time. Could you cite instances in your legal career which would show that you have the qualities, not just the experience and the knowledge needed by the next Chief Justice, particularly when it comes to drawing your colleagues in the court to agree with you, to build a consensus in order to achieve a vision and to accomplish the reforms that you are setting forth?
And you're asking, Your Honor, for specific episodes in my own career. Well, I will have to fall back on my experience as dean at the UP College of Law, because presiding over a faculty would require me to bring together the faculty to accept measures that perhaps normally might be resisted. I'll give details. They might be boring outside an academic setting, but even the simple exercise of a teaching evaluation survey, where teachers are basically graded by the students, can be resisted. The simple exercise of having a dialogue between which we have institutionalized, by the way, between the faculty and students, is something that otherwise might be resisted. And I'm very pleased to say that those reforms have taken root, and in fact, today, long after I have stepped down, they continue to be carried out. So what I'm saying is that handled otherwise with less care and with less sensitivity, these are reforms that might be resisted by the more traditional faculty, but in that context were accepted.
Thank you, Dean. May I just make a follow-up? Because you mentioned in an evaluation process among the professors of law in the College of Law, there is also need for us to look into the possibility of an evaluation system also for the performance of judges in order to aid all agencies, including the JBC, for promotion, for perhaps incentives, that is something that can be done, in the future, so that those judges who actually perform better are rewarded accordingly. Not just, we don't have to wait for a Judicial Excellence Award, to happen. If they perform silently and they're able to declog their dockets, and perhaps they should also be given and afforded the merit and the recognition. So with that, Mr. Justice Peralta, I have no further questions. Thank you. Good luck, Dean.
Salamat po.
Attorney Mejia?
Thank you, Justice Peralta. Good afternoon, Dean Pangalangan. Alam niyo po, meron kasi kaming usapan dito sa JBC na nag-impose kami ng time limitation among ourselves, kaya medyo mahigpit po ang aming chair sa pagbibigay ng panahon sa opening statement, no? Tinitingnan ko po yung opening statement niyo, mukhang maikli lang naman, at nasa live coverage tayo. Willing po akong ibigay yung panahon ko sa inyo kung gusto ninyong basahin yung opening statement.
Salamat po. Thank you, Your Honor. I have actually delivered parts of my opening statement, but let me just summarize. Your Honor, the court today works under two, I will call them historical moments. The first I have already mentioned, the 25th anniversary of the 1987 Constitution. And the second I have likewise mentioned under questioning by Congressman Tupas, which is the recent impeachment of the former Chief Justice. But that then brings the court into the question of continuing the path of judicial activism or exercising judicial restraint. And I'm more on the side of judicial restraint. Now, admittedly, at this stage of our history, it is difficult to be that restrained because, for instance, many of the large causes, social and economic equality, environmental protection, these have all been codified into law. So even if a court says that it doesn't want to get involved in substantive policy matters, there is no choice. There is a codified either right or obligation under the rules. But as I've said earlier, there are also countervailing judicial doctrines by which a court can defer to the political branches of government and enable them to perform their respective duties. And for me, the important thing for a court is not to dissipate its legitimacy needlessly. In other words, there are some political debates that are best left to the political process. And that for a court to jump into the fray will therefore actually bring down the court from its Olympian perch and reduce the court to just another political player, open season to the elected branches of government. And that is the difficulty there. And that is why, in fact, which brings us back to why at some point the court had to create the position of an official spokesman, because the court had to answer the criticisms from the political branches of government, which were completely free to comment and to debate, whereas the court was, by tradition and by law, limited just to its functions, to its adjudicative functions. The common thread, Your Honor, therefore, is that at this particular moment, a Chief Justice would have to rise above I call it the grayness of reality, to see the place of the court in the grand constitutional design. And I will, my preferred definition of the judicial power is, and here I quote, the shaping and application of those wise restraints that make us free. Thank you, Your Honor.
Thank you. Some of the questions that I had for you were already addressed in your with the questions of, or by the questions of Attorney Cayosa. So let me go to some of the questions that were tweeted, no? And we will give you an opportunity to address this. apparently, a number of UP professors opposed your appointment as dean. Can you please clarify or clarify this particular incident?
Yes, Your Honor, and thank you for giving me a chance to address that point. I stood for the deanship for the first time in 1999, and there was a group of professors who supported a different candidate. I took part in all the public forums because that's part of the UP system. The dean nominees appear in public forums. I took part in all those forums. Well, unfortunately, their candidate did not, but they did campaign quite actively for their candidate with the posters and all. But, you know, as history shows, Your Honor, I won and they lost. And that group of faculty members protested my appointment. I am, again, very thankful for my most senior colleagues in the faculty for having supported me throughout that battle. And I went on to serve my first term of 3 years. My performance was reviewed at the end of those 3 years, and I was given a fresh mandate with the full support of my faculty.
My final question po, another suggested question. How should the Philippines and China resolve the issue on the Scarborough Shoal?
Your Honor, there are two ways to look at it, the legal and the political. On the legal, the most important point, whether we're dealing with Scarborough or Spratlys, is to define how we characterize the rocks at Scarborough Shoal. Those are 5 isolated rocks the only land jutting over the water, even at high tide, at Scarborough. In contrast, for instance, to Spratlys, where we have real islands existing. And having defined how we characterize the features, that's the generic term, the features, then we can determine whether these are islands that we must own because they are land and which therefore generate their own maritime zones, their own territorial sea and exclusive economic zone and continental shelf. That is one, to see them as islands, or to characterize the Scarborough either as rocks, which generate only a territorial sea, not an exclusive economic zone, and also to lay our claim over that part of the shoal which is actually underwater, and consider them as part of our exclusive economic zone squarely under our sovereign rights. That is the legal part. Of course, Your Honor, on the political part, it is well, I will have to defer to our Foreign Secretary on this point, but I do support his position that we have to multilateralize the dispute. It is not purely between a small country, the Philippines, versus a big country, China, that it is actually a multilateral dispute among several ASEAN countries vis-a-vis China, over which the ASEAN holds a common interest.
Thank you, Dean. Good luck. Thank you po, Justice Peralta.
Justice Lagman, please.
I have only very few questions because of most of the questions which I have prepared have already been asked, and I found the answer of the Dean very satisfactory.
Salamat po.
Okay. Now, past Chief Justices have been remembered for the judicial reforms they have instituted during their incumbency. Now, Dean, if you will be fortunate to be nominated and appointed as the next Chief Justice, can you describe to us the face of a Pangalangan court?
Okay. That is a difficult question, Your Honor. Your Honor, you mentioned that Chief Justices were identified by the administrative reforms.
Yes.
I would like the legacy, if I'm given the opportunity,
yes.
to be both administrative and judicial.
Judicial, yes.
That is for a court which spoke with a clear voice. In other words, I see it as part of the role of a Chief Justice to bring his colleagues together toward a core agreement on the most important issues. To speak with a clear voice on constitutional norms. And so for me, it is a court that will be identified with living up to the loftiest dreams of the 1987 Constitution, because that was a constitution brought about by a rupture between the martial law era and the post-Marcos era. So I'm trying to find a brief way to describe that. Well, Your Honor, it will be a court that exercised its judicial power judiciously. That is how I will summarize it.
Okay. Now, my last question, Dean. Now, if you will be the next Chief Justice, can you tell us what will be your top 3 priorities upon assumption of office?
Okay, Your Honor. I can think of just 2 right now, but I'll think of a third along the way. Well, Your Honor,
okay.
The most urgent and the most obvious is the consolidation of the institution, because we are here today because of a dramatic and I would say traumatic process by which a Chief Justice was unseated. And I think the institution has to consolidate itself, both internally within the Supreme Court, at the level of the justices, at the level of the staff, the court vis-a-vis the Supreme Court vis-a-vis the lower courts, all the way to the trial judges, and for that matter, the court vis-a-vis the other branches of government. That, of course, will be sensitive, but I think it is something that ought to be done, and the best time to do it is as soon as a new Chief Justice takes over, so that he can take advantage of the momentum of that appointment. That's the first. The second, Your Honor, is which brings me back to what I call the managerial approach. You see, Your Honor, in terms of administrative reforms within the courts, I have been part of the Supreme Court committees, many Supreme Court committees in the past, and my feeling really is that all the bright ideas on judicial reform have already been expressed. I'd rather not reinvent the wheel. I think we are now at the stage of implementing all those wonderful ideas, and it is in the process of implementation that we have to ask ourselves, how come some reforms are not easily embraced by the practitioners, for instance, that even if the judge wants, even if the judge, for instance, has a policy of no postponements, what if both parties basically agree and present it as a fait accompli? So for me, the administrative reforms which have been laid out from the action plan for judicial reform from 2001 to 2006, I think were written well because they looked at the court as an administration, as an organization. And now we are at the stage of implementing that. Well, in terms of the third, Your Honor, in much the same, I will do exactly what I did in my past administrative positions and address the question of staff morale and staff benefits. For me, the institution thrives upon its lowliest employees. And these are the staff whose benefits are minuscule compared to the rest, whose problems fall through the cracks and can be forgotten in the course of the more earth-shaking decisions. faced by the highest administrators. And my feeling then and my feeling now is that that is something that ought to be given importance.
Okay. Thank you very much, Dean, and good luck.
Salamat po.
Justice Hermosissima, sir.
Well, good afternoon, Dean.
Good afternoon po.
I have interviewed and nominated Dean Pangalanan several times before, revealing his excellent qualifications.
Salamat.
And so I will ask no more questions.
Oh,
Thank you.
thank you, sir.
Secretary Mosngi.
Magandang hapon po, Dean Pangalangan.
Good afternoon po, sir.
Someone earlier mentioned that the Supreme Court right now is a wounded court after the impeachment. You touched on this very briefly kanina sa mga katanungan sa inyo. Pero specifically and more definitely, I hope, if you are appointed Chief Justice, how will you unify the Supreme Court and resolve the sense of fracture and a divided court that is right now?
Thank you, Your Honor. In fact, this gives me a chance to explain more detail what I explained earlier. Your Honor, it is the process of reaching out, which is important. To reach out to all members of the court, or for that matter, people outside the court, to reach out, to sit down, and to talk. That is why, in operational terms, what is worrisome there is that that is a process which requires a lot of meetings, a lot of time sitting down and talking to people. But in my experience, also given Philippine culture, it is those face-to-face meetings, not necessarily big meetings, they can be quiet conversations, that can heal wounds, forge working relationships among estranged parties, and hopefully over time can bring together a fractured institution to work together.
Thank you for that, Dean. Your reputation precedes you, Dean Pangalangan. But I believe that no matter how impeccable your professional record may be, criticisms are inevitable. To your mind, what was the worst personal or work-related criticism against you, and how did you deal with this before?
Well, the worst criticism I received was in that episode mentioned earlier already before the council, and that was when I was opposed as dean of the UP College of Law. And the criticism was I was a dean that was loved by no one except his wife. My wife is here, Professor Elizabeth Pangalangan, a professor of persons and family relations. And I remember that when that was first uttered in public, someone nudged me on the elbow and said, "Hey, that must be a good thing. That even if the whole world turns against you, your wife is still there beside you." So if your question, Your Honor, is the worst thing that was said, I would take that as the worst. Fortunately, mercifully, providentially for me, by the time I presided over my first faculty meeting, I realized that it wasn't true. That I, in fact, enjoyed the support of my colleagues, and especially my most senior colleagues in the faculty. And they sustained that support over the next 6 years of my deanship.
Chairman, I have no further questions. I wish you well and best of luck, Dean Pangalangan.
Just a follow-up question, Dean. What happened to those who were opposing you?
Well, Your Honor,
Did they continue teaching, or did they take a leave of absence?
Well, one, Your Honor, was already on leave of absence at the time I took over the opposing candidate, because he went on leave under my predecessor, because he was the opposing candidate then. And anyway, some of them went on leave, and I granted their leave. They applied for leave, and I granted it. I will not stand in the way of people's plans.
Did they rejoin the faculty during your incumbency?
In fact, Your Honor, some who opposed and who continued teaching were so welcome to continue teaching.
But they did not continue teaching.
Well, I would say I'm absolutely sure about one who actually continued teaching, continued to oppose me, but that's okay for me. I was dean, and I welcome all voices in the faculty.
The others did not anymore teach.
The others went on leave and found opportunities elsewhere. And again, I am happy for them if they find that they found those opportunities.
The other question is that you are from the academe, no?
Opo.
Some of the applicants are private practitioners.
Opo.
My question is, what is your edge over these applicants, practitioners?
Your Honor, the luxury of a professor is that he can take a broad view of things. That if I worked, for instance, with my father, who was a litigator.
How is he? He used to appear before me. How is he?
He is turning 87 this year, Your Honor. His health is
Does he still appear in Sandigan Bayan? No more?
No more, Your Honor.
Okay, then go ahead with your answer.
Well, thank you. Thank you, Your Honor, for asking, and I will convey to him your question. And I realized when I was working with him that I was fortunate that I was able to do some teaching. And now, of course, I principally do teaching. Because if I was buried in the routine of everyday deadlines, I will not be able to step back and look at what is happening. Concretely, for instance, Your Honor, practitioners would go to the courtroom and look at the calendar, see where they're, what number they are. Of course, there would be side comments saying, "Oh, there are 40. Siguro mga tatlo lang mahihiring dyan." You see, it takes the luxury of a professor to look more deeply into that setup. And that is why the court eventually has adopted all these reforms. The court is piloting this continuous trial system. But I think that someone immersed in that situation will have neither the time nor the energy nor the inclination to reform that. He will just see it as, well, today I'm number 10. Maybe I will have to wait for about 1 or 2 hours, but that's okay. That's my morning for today, and I will move on for my next hearing, my next deadline. So it takes the reforms will have to come from those who are either released from that burden, or who would be tasked precisely to take that long view. And that is the advantage of the professor.
Your forte is public law?
That is correct, Your Honor.
And international law?
Opo.
You are in favor of, supposing there's a charter change, you're in favor, once you are a Chief Justice, no? You're appointed a Chief Justice. Are you in favor of retaining the power of the Supreme Court under Article 8? Is that Section 1?
That is correct, yes.
Based on grave abuse of discretion to review even the acts of
yes.
the two branches of government?
Yes. Your Honor, my short answer is I'm rather conservative on many things. And on this point, for me, I'm prepared to accept the text as it is. Because, Your Honor, it is not a problem with the text. It is a problem with those who interpret the text. Because there is a way to read that expanded power without, dragging the court into the political thicket. Of course, ideally, Your Honor, we can refine that language. After all, grave abuse of discretion, originally under Rule 65, was a check on judicial discretion, discretion which is highly circumscribed. And now we apply the grave abuse of discretion test on open-ended political discretion by all instrumentalities of government. That is, of course, that opens the floodgates. But I've said there are ways to, there's sluice gates by which to rein it back. So my focus, Your Honor, is less on the amendment of the constitutional text. It is more on the refinement of judicial interpretation.
Okay. Last question. I do not know if this is your answer will be very long, but it's my last question because already 1 o'clock in the afternoon. Can you name or state rather 3 major problems that now beset the court, and can you give solutions or what your solutions would be? Mahaba ba yun?
Opo, tatlo pa
3 major problems, then state or give you solutions.
Okay, sir. Let's start with the most familiar, the recruitment of the best and the brightest into the legal profession. I have been bar examiner twice.
You should have been included when you apply. You should have been appointed a long time ago.
I'm sorry?
You said that you have to recruit the brightest. Then you should have been already appointed a long time ago as member of the court.
Oh, well, thank you, Your Honor, for the kind thoughts. But, Your Honor, the bar exams. During my IBP presentation, I openly, publicly recognized the most radical reforms carried out by the Supreme Court, and I said that the way it was implemented was the way to go. This is the shift to the MCQs, the multiple choice questions. I appreciated as a professor the careful way by which the reforms were phased in. It was gradual. It was with full consultation with the law schools, their faculty, and their deans. Of course, the process has the process. Mr. Chairman, I was referring to the bar exam reforms. The process continues today, but that is the way to do it. Of course, I know that I'm promoting another applicant before the court, but I do appreciate the work that Justice Abad has done. But for me, I was on the Supreme Court Committee on Legal Education that reviewed this. The original proposal on MCQs was for a sitting panel of examiners. And for me, what I call the present system, which is built on what is a solitary bar examiner, appointed confidentially every year, serves for 1 year, then moves on to other things, is the best guarantee that there is no institutional memory. In other words, Your Honor, kung may mali this year, either in the design of the questions, in the allocation of points, in the focus of the cases, there is no institutional memory by which to carry that forward. And so it's like every bar examiner starts afresh. And for me, it is important to have a way by which to to collect the wisdom, the accrued wisdom over the years, so that the examinees are not caught by surprise, so that they have a relatively stable expectation of the range of questions, etc., etc. That is on the selection of lawyers. Second, Your Honor, the teaching of ethics. You see, Your Honor, with ethics, it is easy to do more of the same thing. In other words, more points in the bar exam. I mean, greater percentage in the bar exam, more courses to be taught, more seminars, more MCLE credits required. Your Honor, I think it is time to focus less on the quantitative and more on the qualitative. It is the approach. Because with the current approach, by teaching students and lawyers more and more of the ethical rules, they also learn more and more of the loopholes. And then at that stage, what is the stock response?
That's how lawyers are.
Well, Your Honor, precisely, that's my point. We must transform the hearts and minds of lawyers. And that is why, Your Honor, what is I call it a cop-out. They say that, oh, we are just teachers. We can just shape their minds. The shaping of their hearts will happen in their homes, in their churches, elsewhere, anywhere else, but not the classroom. I contest that, Your Honor, because the teaching of ethics should not just be teaching about rules. I call it, my preferred approach is recognition of moral choice. That lawyers must realize that in their day-to-day life, the most mundane decisions are actually moral choices. And that is why they must recognize the moral dimension of otherwise, mundane choices and act upon them. So, sure, the acting upon them is still a matter of conscience, but they have to confront it as a matter of conscience and not to see it purely as a matter of the technical application of rules, which will then pave the way for a lawyer, given a choice between the loophole and the right thing to do, to choose the loophole. Well, the third, Your Honor, just so that I can move forward, is something that I have discussed earlier, which is the managerial approach to managerial and proactive approach to the recruitment of judges, because it is my sense and it is my hope that we have a changing profile, Your Honor, of students today. If you notice, 10 years ago when I was dean, there were about 80, 85 law schools. Today, I think we have 120. It used to be that UP was the only law school with full-time professors and full-time students. Now there is a trend toward more and more full-time students. If one looks at that changing profile, there is a parallel transformation in the profile of the careers that they take. For instance, Your Honor, if we look at the recent bar exam reforms in Japan and Korea, it used to be that the passing rate in Japan was like 4 to 5%. Korea was 2 to 3%. Now they have instituted reforms. They have copied our system of education and our bar exam system. They're aiming at 20 to 25. The difference, Your Honor, is that because they belong to the continental tradition, students choose their career path toward the last 2 years of their life as law students. In other words, they already choose their focus, whether they would like to be members of the judiciary, members of the prosecutorial service, or members of the practicing bar. And maybe we can take that direction. We have already actually taken one major step in that direction, the Philippine Judicial Academy. And I have for a long time been on the faculty of the PhilJA. And my experience there is that until PhilJA, it wasn't just that the judges had no opportunity for, in effect, continuing legal education. For me, it was more than just the academic. For lack of a better word, I call it the social. They had no opportunities, they had very little opportunity to sit down and exchange notes, exchange experiences as judges with fellow judges on the day-to-day work that they face.
You are in favor of MCQ in the bar exams?
Yes, Your Honor. I voted for it under the Committee of Justice Vitug, but that was...
But I understand UP, not a single student from UP landed in the top 10.
Your Honor, well...
the MCQ.
Well, Your Honor, the UP had a very good...
There will be more faculty members who will oppose you in UP.
No, Your Honor. The passing rate of UP was very good. So okay. We looked at the passing rate,
it's not gauged by the top
not the top 10. And also, Your Honor, when I voted for the MCQ, it was on the assumption that there will be a sitting panel of examiners who will bounce off the questions unto one another. So this year, I sat on the validation committee of Justice Abad to review the questions in political law after it was given, to comment on the questions. For me, that is, of course, a wonderful innovation by Justice Abad. But what I would add is, if there was a panel, there could have been a preliminary vetting of questions.
Oh. Anyway, the present chairman adopted the MCQ. I think he adopted 60% of the questions will be MCQ. The 40 questions will be the essay type. So in each subject, 60% of which will be MCQ. The 40% will be essay. So there's a little innovation of the bar exams this year. Because I think last year there were no essay questions, purely MCQ, and then the writing memorandum, and so on. Okay.
Well,
on that note, thank you very much, Dean.
well, thank you also, Your Honor.
Okay. Good luck.
Salamat po. Thank you.
Now, it's already 1:10, so we will suspend our proceedings. We will begin at 2:30 in the afternoon.
Okay lang naman to dito, no?